development or subsequent development, inform the court that we want to file. Court will definitely consider and allow. But on your own, you cannot just, like, I want to file, I'll file. Like that. Counsel for the petitioner submits that there are certain subsequent developments which she would like to bring on record by way of an additional affidavit. The prayer is allowed.
She will be filing our affidavit today, madam. So this matter may be.
Let the affidavit be filed within a period of 2 days.
Loss of
Stop. Since the counsel for the private respondent expresses urgency, matter be listed again when?
13th, 12 or 13 losses. 12 or 13 years.
13th. 13th of November 2024. Yes.
If there's an interim order that may be still
Till that date, interim order passed earlier shall continue.
deeply obliged.
Yes.
May I plead the lordship, my lord, I beg to, with due consent from the petitioner, my lord, I beg to mention item number 15 and 16, my lord. My lord, in this matter, my lord, the petitioner has filed affidavit in reply. So regarding that, we need to take some instruction, my lord. So it may come after 3 weeks, my lord. We have taken consent from the petitioner, my lord.
Mr. D. Bora, standing counsel health, submits that he needs to take instructions on the additional affidavit filed by the petitioner.
On the affidavit in reply filed by the petitioner.
On the affidavit in reply filed by the petitioner. And therefore, he may be granted 2 weeks' time for the said purpose.
3 weeks, my lord.
Okay, make it 3 weeks. Stop. As there is no objection from the other side, matters stands adjourned for 3 weeks.
Obliged, my lord.
May it please your lordship. Lordship, in item number 2, lordship, respond number 7, easy. The Assam has to file an affidavit in opposition. I would like to file a reply, lordship. I need 3 weeks time. They are here.
As paid for by learned counsel for the petitioner, 3 weeks' time is granted to file a rejoinder affidavit to the affidavit in opposition filed by the AG Assam. Mr. C. Barua, learned counsel, appears for the AG Assam. Yes.
I beg to mention, my lord, item number 3, my lord, with the consent of the other side, a personal difficulty, my lord, may come up after 2 weeks, my lord.
And for the petitioner, your lordship.
No objection?
No objection.
As paid for by the learned counsel for the respondent and not objected to by the other side, matter stands adjourned for 2 weeks.
Deeply obliged.
May it please your lordship. Item number 12. Item number 12, your lordship, it pertains to termination of the selection, cancellation of the selection process of statistical officers in Morigaon district. So the matter, it's a second round of litigation. The first round of litigation culminated in a review petition in the year 2023. That matter was heard before the Honorable Supreme Court. That SLP was dismissed. There's another SLP on the same matter, which is pertaining to the same selection process, which is pending before the Honorable Supreme Court. So as of now, your lordship, this matter of 2017, which pertains to termination of the petitioners, may not be taken up at this moment, your lordship.
2 SLPs on the same subject.
2 SLPs on the same
One
subject.
dismissed.
One has already been dismissed. Which
So what do you expect on the other SLP?
The
Will it not follow suit?
It will not follow suit, your lordship. In fact, there were 2 vacancies and there were 3 individuals who were appointed to the post of statistical officer in Morigaon district. Now the entire.
Okay, how much time?
Your lordship, I'll leave it to your lordship's convenience. We don't have a.
You're for the respondent?
No, we have the petitioner in this matter, but we have the respondent.
Any objection?
Then they are adjourned.
Counsel for the petitioner submits that related issue is pending before the apex court and therefore the matter may be adjourned for the time being.
Yes, yes.
As paid for, matter stands adjourned for 4 weeks.
Grateful, your lordship.
May I please your lordship? May I please your lordship? Yesterday we had one case, 154 item, but somehow I was stuck up in the CBI court.
Item 54.
Item 150.
54.
54
yesterday, yes.
Yes, interim order is required to be extended and the matter was urgent.
It will be extended provided we hear the parties, madam.
My humble request
See,
is to fix on Monday because my matter is urgent. And on it has been reflected that we have requested the.
Then what do you want me to reflect?
I was not there.
I have reflected that no one is present and it may be taken up after 2 weeks.
It's not there. My name, it is written there, sir. Applicant is on the prayer of the applicant.
Please listen. The initial order was no one appears for the applicant when the matter is called and list the matter after 2 weeks. So there was a request made that interim order be continued and the applicant be present.
Yes, your lord.
When I saw the file, I cannot extend the interim order without hearing the other side.
So
Because on 3 consecutive days, interim order was not extended. That is why you filed the application. So in the absence of hearing of the other side, this court will not pass such kind of orders.
So my
I'm sorry.
only request is that it may kindly be fixed on Monday. Matter is urgent.
You have a mention memo?
Yes, we have
Okay, Monday.
much obliged.
May I please, sir? I beg to mention item number 11, my lord.
Yes.
I am paying adjournment for 2 weeks, my lord. We have some difficulties. my lord.
You are for the,
I am for the petitioner. I have taken consent from the respondent side.
okay. Counsel for the petition expresses difficulty to conduct the case today on a prayer made and not objected to by the other side. Matter stands adjourned for 2 weeks.
Objection.
Lordship, I beg to mention item number 13. Lordship, this matter has become infructuous.
Your name?
My name is not here. I'm on behalf of J Pine.
Yes. Anyway, you tell me your name. Miss A. Payang, learned counsel appearing on behalf of Mr. J. Payang, counsel for the petitioner, submits that the writ petition has become infructuous. Stop. In view of above, the writ petition stands dismissed as infructuous.
Item number
Objection.
23, my lord.
23.
My senior Mr. M.K. Chaudhary is leading me in this matter. He
Hmm.
has some personal difficulty today, and I'm seeking some accommodation. I have taken consent of
Mr. M.K. Chaudhary, learned senior counsel appearing for the petitioner, is said to have some personal difficulties to appear before the court today. Stop. On a prayer made on his behalf and not objected to by the other side, matter stands adjourned for a week. All right.
May it please, my lords. I'd
Yes.
like to mention item number 10, my lords. I'm seeking a week's accommodation, my lords. I appear for the respondent. my lord.
Have you informed the other side?
I am for the petitioner, my lord.
Sorry?
I am for the petitioner.
Any objection? On the prayer made by learned standing counsel
My
APDCL
lords.
and not objected to by the other side, matter stands adjourned for a week.
I'm deeply obliged.
Wait, wait, Lord.
Yes.
Well, by this petition, my lord, the petitioner has challenged the appointment of respondent, selection and appointment of respondent number 8, my lord, as Anganwadi helper.
Anganwadi worker,
Helper.
helper.
Yes.
How was she appointed?
My lord,
What is the
Yes.
procedure?
there is no procedure, my lord, prescribed in any, there is no rule, my lord, as per the.
If there is no procedure, then how can you challenge it also?
Well, only
They'll
the,
appoint whoever they want to.
the procedure, only procedure, my lord, she must be the selectee must be a candidate of the local Anganwadi center.
Yeah, that's the procedure.
My lord. The respondent number 8 is not the local resident of that particular Anganwadi center, ma'am.
Hmm.
It is not the allegation of the petitioner. It has been found by the,
So where is the specific allegation made by you? Or first of all, you point out the appointment.
my lord.
Appointment is at page
Select list, you will find page 18, my lord.
18.
18, annexure 2.
Where is the respondent number 8?
Respondent number 8, name has been inserted by hand, my lord.
Jima,
Patil, my lord.
what is this? P-A-T-I?
R.
Patir. Okay.
Yes.
And below that? This is
Below-
another name.
Below that name, there's nothing, no name is mentioned.
No, there's one name, Dulai, Doli or something like that.
In annexure 18, my lord.
Page
Sorry,
18.
Page 18, my lord. Only Jimapati name is the last name, my lord.
No, handwritten is also there. You don't have that.
In my petition, my lord.
In my copy is Jima Patir, then below that Dular Dole.
That is next page, my lord. Page 20. In my petition, that is page 20, my lord.
So you have made your petition a special petition and you've given another petition to the court.
But there's something
Why
wrong.
it's not similar?
Something wrong in paging, my lord.
No, in the next page also same thing. In the next page also there are 1, 2, 3, 4, 5, 6 names.
Right.
Handwritten. In page 19. Page 18 has got 2 handwritten names.
Yes, here, my lord, page Three names.
Anyway, we are concerned with Jima Patir only.
Yes,
She is respondent number
8, my lord.
8.
Now your lordship kindly consider annexure 3, my lord. The fi-
Annexure 3.
Yes, my lord. The finding of joint verification, my lord. Annexure 3,
This is a type copy.
it's a type copy. Originally it was there, my lord.
Was alleged to be an outsider. Hence,
Yes,
the committee
yes.
suggested proper verification
Yes, my lord.
be conducted. Result may be withheld.
Yes.
Then,
Then, my lord, another verification report we have come across, my lord. It was dated, my lord, 9.
another means what? Where is the previous one?
This was the annexure 3 is the, my lord, previous one.
What is the date otherwise? There's no date also.
My lord, that is there, my lord. It was dated 5th of June 2010, man.
Where? From where you're seeing that?
Annexure 3 last page, man. Signed by the Joint Secretary, 9/6/2010, man.
Nine six.
Yes. Thereafter, another, my
No,
lord,
before that, see, what is this? Page 20 is annexure 3.
my lord.
Page 21 is also annexure 3. There are two annexure 3.
My lord, read petition number is, my lord, is it, my lord?
I think page 20,
My lord,
it is an abstract of that particular serial number 9
my lord.
at page 23.
Yes, my lord.
Okay. 9 June.
Another joint verification was conducted, my lord. It was dated 19/1/2023, my lord. I could not submit it, my lord, before the honorable court along with the, my lord, petition because I have got it, my lord, very recently. May I submit that, my lord, joint verification report? It was
No,
dated, my lord, 19/1/2013, my lord.
no, what happened to this particular verification first? You tell me that.
Despite that, my lord, the petition respondent number 8 has been selected, my lord. And
No, that's a different thing. My question was,
my lord.
the selection or recommendation was withheld because of the complaint. By this recommendation dated 9/6/2010, it was said that verification should be done.
Press advertisement,
Was it done?
my lord. Subsequently, it was done, my lord, on 19/1/2013, my lord. It says, my lord, this is report reveals that due to non-demarcation of the boundary of the Anganwadi center, the residential status of the candidates could not be ascertained, my lord.
Verification report dated?
It's a dated, my lord, 19/1/2013, my lord.
Which is exit?
The extra copy, no, my
No
lord.
extra copy, you have to be part of the record.
According to them,
Verification report is 19/1,
my
2013.
lord, it says, my lord, this is report reveals that due to non-demarcation of the boundary of the Anganwadi center, residential status of the candidates could not be ascertained. Thereafter, what happened, my lord, they have, after filing of the writ petition, stated that press advertisement was issued, my lord, on 2013.
Fresh?
Advertisement was issued
Okay.
2013, my lord.
In 2013.
2013, wherein the respondent number 8 has been once again selected, my lord.
Okay.
My contention is that, my lord, that Anganwadi center's boundary was yet to be, my lord, told, my lord, demarcated in terms of this my joint verification report of 19/1/2013. My lord. The respondent number 8 has already been held to be an outsider in the earlier joint verification, my lord.
Where?
Annexure 3, my lord. As I have shown your lord.
It doesn't say that.
It says, my lord.
There's an allegation that she's an outsider. Allegation. Anybody may allege against you also. He is alleged to be a male person, not a female.
She is actually an outsider, my lord.
Oh, how do we know that?
That's why the press advertisement was issued, my lord.
Your submission
And
that
that-
she's
that-
actually is an outsider will not do. Verification has to be done
My lord.
and proper finding has to be done. Your paper which you have today, you're trying to produce, doesn't say anything. It says that boundary has not been settled, so cannot be done. So
My lord.
it is neither here nor there.
Annexure 3, my lord, kindly peruse, my lord.
Hmm?
Annexure 3, the my lord, findings of the my lord, joint verification committee, my lord, observation in serial number 9, my lord, page 23. Pertaining to number 2, Khojua Party. It says, my lord,
Yeah, read.
candidate Jima Party who secured highest mark was alleged to be an outsider. Hence, the committee suggested that the proper verification in respect of the residence of the said candidate be conducted to ascertain the residence, and result may be withheld. There is no any verification conducted as to ascertainment of the residence of respondent number 8, my lord.
So there is no conclusion that she's an outsider.
My lord,
You are saying that there's already a verification.
my lord.
The verification doesn't say that she's an outsider. It says that the boundary has not been settled, so there cannot be any.
Subsequently, by another verification, it was 19/1/2013, my lord. It says, my lord, the Anganwadi center's boundary itself is, my lord, disputed, my lord. And
This-
interestingly, your lordship will find the affidavit filed by respondent number 8, my lord.
Yes, what does it say?
Says, my lord, page 10 of the affidavit, my lord. Page 10.
Filed by respondent number 5.
Respondent number 8, my lord. The private respondent, selected candidate.
Yes. Paragraph?
Page 10, my lord, annexure 2. Type copy of the advertisement.
Yes.
At the top, my lord, the date of the advertisement. my lord.
Yes.
8/4/2013, my lord.
Yes.
The certificate annex regarding her residence, my lord. Your lordship will find page 9, my lord.
Where's the translation?
Translation, my lord, page 8.
Khojua Party gone.
It was dated, my 19/7/2014, my lord, after issuance of the advertisement.
So
My basic criteria of the requirement of a candidate, my lord, she must be a candidate.
have you filed any representation?
My lord, representation was filed.
She's already appointed, isn't it? Respondent number 8. Working.
My lord.
She's working.
My lord,
You file one representation before the director, they'll consider
my lord.
what can be done by this court. I don't think anything can be done.
Yes, my lord. The lordship must dispose of my lord directly.
Heard Mr. PJ Saike.
Lordship,
Yes.
just a minute, I just want to point out
Ah,
something, Lordship.
Yes.
This admitted to Lordship, the petitioner is seeking appointment as Anganwadi helper, Lordship. The counsel is referring to page 21 of this writ petition, Lordship. Kindly peruse for a moment, Lordship. Page 21.
Yes.
And page 20 is the abstract, which is typed. Page 21, Lordship, kindly see, first one is Anganwadi workers. This one, Lordship. Then second one is Anganwadi helpers, Lordship.
Yes.
In Anganwadi workers also, number 2, Khojua Party, where it pertains to workers only. And the comments is on the part of the appointment regarding Anganwadi worker. Lordship may kindly peruse the Anganwadi helpers, the second column, Lordship. Here, Lordship, in serial number 6, number 2, Khojua Patir, Srimati Jima Patir, name of the candidate. Then, Lordship, local of center area. She resides permanently in center area. This is the finding, and this is the residential status of the pertains to all the workers and helpers, Lordship. So, how they can refer? Because this is deliberately done by the petitioner lordship. Instead of seeking these things regarding the helper, they have pointed out this regarding the Anganwadi worker only, which is not appropriate lordship.
Well, I have
So
not-
this has been,
I am not referred to as worker. I am saying.
so lordship, this one may kindly be noted lordship.
No, we are concerned with helper, isn't it?
Yes, we have to be concerned with helper because the petitioner is seeking for the post of
Helper,
helper only, lordship.
No, that's why. Why are you referring to worker then?
It is divided into 3 columns, lordship, the whole table.
Yes, 3 columns.
Yes, first one is Anganwadi worker,
Hmm.
middle one is the
Helper.
Anganwadi helper, and second is mini Anganwadi workers.
Yes.
So Anganwadi workers, we are not concerned with this because the petitioner is not seeking appointment for the post of Anganwadi
Correct. We're
worker.
not concerned. Yes.
We are concerned with the Anganwadi helpers.
Yes.
So in respect of Anganwadi helpers lordship, when it comes to number 2 Khajuapati, that means that where the petitioner is seeking her appointment, the disputing lordship, here it is number 2 Khajuapati, serial number 6 in the middle column lordship.
Hmm.
So then the name of the candidate Jima Patir.
Who is
Lo-
she? Jima Patil. She is the respondent number 8.
Yes, lordship,
Hmm.
respondent number 8. And lordship, in the left side it is written, this is the residential status lordship, local of center area. She resides permanently in center area. This is mentioned lordship.
Yes.
But the
So
observation, your lordship, will-
this is their lordship. This is there because this is the joint verification report conducted by the authorities lordship.
Then you come to page 23,
yes,
Lordship.
serial number 9. One more observation
yes.
is there. Candidate Srimati Jima Patir Dole,
Yes.
who secured highest marks, was alleged to be an outsider. Hence, committee suggests that proper verification in respect to residence of the said candidate be conducted to ascertain her residence.
Lordship.
Result
So
may be
this is
withheld. So this is dated 11/1/2011.
Lordship. Then
So,
subsequently, lordship.
Fresh advertisement was made
Yes, in 2013,
13.
interview was held.
and she was
lordship.
selected again.
Yes, in 2013, interview was held, lordship. We have our affidavit also.
Mm.
In the interview, only 2 candidates had appeared for the post of Anganwadi helper as per comparative statement, lordship. And from there, it is seen that Jima Patir Dole, because the earlier one is pertains to 2009, lordship. Advertisement of the year 2009.
Okay.
The big, well, the
And we
affidavit was
have,
filed.
please, let me submit.
So this 2013 advertisement,
Yes, lordship.
selection was done and
Selection
she was
done,
selected.
Then it was duly approved. Approval was given by the director.
Was there any other verification again?
That was suppressed, my lord.
Hmm?
That is my contention. That was suppressed, my lord. That was not brought on record by the government, my lord. I have copy, my lord. Lordship kindly peruse that.
The advertisement of 8/4/2013, lordship, because the earlier advertisement goes, lordship. Earlier advertisement goes. We have this lordship of 8/4/2013 advertisement, lordship. And subsequently, lordship, in that particular, after that advertisement, lordship, only 2 candidates were there, who have appeared for the post of helper, and we have the record, and this has been done as per selection. That means their performance in the interview and the subsequent verification of all the documents and records, lordship.
No, my question was,
Yes.
subsequent selection was done, but was there any other verification regarding the residential address or residence of the respondent number 8?
Lordship, because the earlier, because this already has been, I think, cancelled, lordship, because there is no, it was of 2009, lordship, as I have said. So now the appointment is on the another advertisement, lordship. of
Correct.
2013.
Correct, but it pertains to the same area only, isn't it?
Same Anganwadi center.
Mr. PJ Saikia, please take your seat. Let me question Mr. You take turns, okay? If both of you reply like that, I'm not willing to hear the matter. Ms. Bhattacharjee,
Lordship.
see, The story is that in 2009, please listen, 2009 advertisement was there. We are concerned with the Anganwadi helper.
Lordship.
And there was a verification done. Respondent number 8 was selected,
Lordship.
recommended.
Yes.
But there is a observation that since there is some allegation that she's an outsider, let verification be done.
Lordship.
Question is, was verification done?
That we don't have any instruction on that particular point, Lordship,
Okay,
but
you have no instruction. Now, thereafter, in 2013, one more advertisement came for the same post,
for
for the same post. And this time she was again selected.
Yes, she was elected.
Now, on what basis was the selection made?
On the basis of the certificate provided by the village headman, Lordship.
What
Yes,
about
yes.
the residential address of the person concerned, respondent number 8?
Yes, it is. He
Any
in our record.
finding that she's a insider? She's from the
Yes,
locality.
Lordship, as per the certificate issued by the village headman, it is there. She is a resident of this. We have this, Lordship.
Village headman certificate is dated 2014.
No, it's of 24/1/2013.
Where is that?
Yes, in our record, Lordship.
In your record?
Yes, Lordship.
You have not filed it?
We have filed the affidavit, but this
Without the-
honorable court has directed to produce as the record, Lordship. So accordingly, we are with the record.
Where is your affidavit? Let's see.
Our affidavit dated 7/11/23, Lordship. Filed by respondent number 5.
Who's respondent number 5?
He is the I see the CDPO, Lordship.
CDPO.
Yes, Lordship.
What have you stated in your affidavit?
Lordship may kindly refer to our paragraph 4.
4.
Yes, Lordship.
Advertisement, then interview, then mm, 2 candidates,
Yes, Lordship.
then who's the other candidate? Petitioner.
Petitioner and the private respondent, Lordship. 2
And
candidates only
again,
appeared,
again, the respondent number 8 scored the highest marks
Lordship.
and placed in the first position.
Yes.
Then approval for directorate, merit list,
Yes, Lordship.
then
Because in other centers also, Lordship, interview was held. So accordingly, the whole list was sent to the director for approval, and accordingly, the approval was granted by the director, Lordship, and they were appointed.
What does the-
These are they have accepted their appointment.
what does the record reveal? Is it in English or it's in vernacular?
Yes, Lordship, that's right.
It's in vernacular.
Vernacular, Lordship, but some are in English also, Lordship. Only the this one issued by the village headman, Lordship, this is in vernacular. And
What is the date?
advertisement? This is of 24/1/2013.
24/1/2013.
2013, Lordship.
You come to the affidavit of the respondent number 8
Lordship.
at page 8 and 9. This is also residential certificate.
Page 8, Lordship.
Yes, 8 is the translation, 9 is the vernacular.
19/7. Okay.
Have you seen it? Have you got it?
Lordship,
Page
Lordship.
8, page
Yes,
9,
yes, yes, Lordship.
8 and 9.
Lordship, I have seen.
8 is the
9/7/2000,
translation.
yes. The
It says
particular is in 9.
9/7 or 19/7?
2014. I just don't know, Lordship, because this is as per record what we are having, Lordship.
Counsel, you're the respondent number 8.
They can say, Lordship, verify.
Why you submitted different certificate before the authority and different certificate in your affidavit? Different date.
I'm appearing on behalf of B. Bura, my lord.
That is why I'm asking you. You are for the respondent number 8.
Yes, lord.
Why you are submitting two different certificates? One is 19/7/2014. This is after the advertisement. And the one which you submitted before the department, this was in the year 2013. What is the date, Ms. Bhattacharya? Date?
24/1/2013, if I am not missing.
24/1/2013.
Is there, Lord. Yes, 24/1/2013, Lordship.
24/1/2013. That is before the advertisement.
The advertisement, Lordship. Advertisement was of April 2013, Lordship.
Why did you submit the another certificate?
Lordship, I do not know about it.
You must be knowing it. You have submitted the original one.
Yes, sir.
So to file your counter affidavit, you again approach the authority. Give me one more certificate. I think that is how it happened. Probably.
And if your lordship considers the selection list, my lord, of the respondent number 8 and respondent number 5, my lord.
As per lordship advertisement, 2013, 8/4/2013, respondent number 8 was selected and also was appointed.
Respondent number 8's name is, what is her name?
Jima Patil.
Jima Patil, lordship. Appointment was on 1/9/2024, lordship. 1/9.
She secured 33.25
Yes, sir.
marks. Petitioner scored 19.5 marks.
Now, your lordship kindly consider, my lord, the select list annexed by the respondent number 8 and the respondent number 5, my lord.
Select list.
My lord. Comparative statement of marks.
Annexed by,
Annexed by respondent number 5 and 8, my lord.
where is that?
In 8, my lord, page 16, my lord, original copy. And in
Yes.
respondent of
So-
5 affidavit, my lord, page 26.
Page?
26, my lord. Complete different.
We have provided from our record, Lordship. Lordship may kindly take
No.
away from the record.
Where is page 26?
It's a affidavit filed by us, Lordship, by the respondent number 5.
Inner page?
Page 26, my lord, annex 1.
Yes. Mr. Sakia, what do you want to show?
Difference of select list, my lord. This is the respondent of 5, 8, my lord, the
How much is the marks? Is there any difference of the marks?
marks,
Is there any difference of the marks?
that is similar.
Then
Every other things are different, my lord.
format is different.
It
But-
cannot be, my lord.
Why not?
Same authority, my lord, committee of selection.
See, it's very simple. Page number 61,
1/6.
61, annexure 1 of the affidavit of respondent number 5. It gives the marks obtained in each field, personality test, given by the chairman, CDPO, medical officer, BDO, separately. But page 51, which is annexed in the counter affidavit of the respondent number 8, I think. This gives the total aggregate score And the total score are same, 33.25 and 19.5. That is the thing. What is there to doubt it? You understand?
To my understanding, my lord, in the.
One is in a bit detail. All the members are giving separate marks, and finally total marks.
My lord.
In the other affidavit, it
Then, my
says
lord,
that
then, my lord, this particular page is easy to, there needs to be in the record, my lord.
in the record, we only have the breakup of marks given by each
Yes.
of the
That is why it is doubtful, my lord. It must be part of the record, my lord, if this is so.
I don't think this should be cause any serious issue on this.
And it also shows, my lord, one thing, my lord. In annexer, in page 16, my lord. Perhaps there is another candidate appeared before the interview period.
Where?
In annexer 16, my lord.
Page 16.
Yes, I'm sorry, page 16, my lord.
Another candidate means?
As my lord, the statement shows, my lord, serial number 123, and in the date of interview, my lord, there is also date is mentioned. Others are remaining unfulfilled.
Lordship, he is referring all these of 2009 selection, Lordship.
No. This 2013.
2013,
Bachaji.
29/6/2013, my lord. Same date, my lord.
Mr. Saikia, I think all these things can be overlooked. You're trying to.
Then I have supplied one copy of the minute, my lord.
Which minutes?
I have already submitted. Kindly peruse that. Serial number 5, my lord, regarding Anganwadi worker, and serial number 5, next column, my lord. It says about Anganwadi helper, my lord. Page. First page, my lord.
Just a minute.
It is a joint verification report signed by the Joint Secretary to the Government of Assam, my lord, dated 21st March 2013. This document was not brought in record, my lord, by filing the affidavit.
Yes, what do you want to show me?
My lord, serial number 5, my lord.
Hmm.
Regarding number 2 Khojwapati Anganwadi Center, against which, my lord, the petitioner is claiming.
This is one thing which have been done, perhaps pursuant to the issuance of the second advertisement.
My lord. To my information, that was not done.
What was the date of the first advertisement?
It was dated, my lord,
2009?
9.
16/9/2009.
16/9/2009. Then 11/1/2011.
11.
Verification.
Verification.
Then fresh advertisement was dated
8/4/2013, Lordship.
8/4/2013.
2013.
Then the final result, approval,
Yes, Lordship. This is in our affidavit, Lordship.
29/6/2020.
approval is given on
In 2014, Lordship.
page 62, I think.
1st August 2014, Lordship. And the next page is the list forwarded by the merit list forwarded by the CDPO, Lordship. District Social Welfare and the CDPO, which has been duly approved, Lordship.
According to the petitioner, respondent number 8 belongs to which place?
He's outsider, my lord.
Outsider means
He-
from where?
She resides in a different village, my lord. That was not mentioned, my lord. I do
Then?
not know where she resides.
You don't know. She
Yes.
says she's from number 2 Kajua Patir.
She claimed.
She claims, and she is supported by the village
Headman.
admin's certificate.
Yes.
Where is there to
That-
doubt it?
Despite that, my lord, the earlier, my lord, when joint verification was conducted, my lord, it has been held that.
No, one cannot go for such kind of
That is why,
roving
my lord,
inquiry.
press advertisement was issued, my lord.
No, if there is some sort of indication that she's from B, not
Right.
from A, it's a different matter. Simply saying that she's an outsider is very vague. We cannot go by that.
Since joint verification was conducted on the spot, my lord, they found, my lord. That is why they have.
It
my
was
lord,
conducted on the spot, but since there is no proper demarcation, they cannot say that she's from this side or that side.
That's why, my lord, second verification report is very, very important. Lordship kindly peruse that.
If it's very important, you have not filed it, you have just shown it to me today.
My lord, very recently we have got it, my lord.
No, this does not say anything. It says
It
DC
says-
report
Yes, my lord.
reveals that due to non-demarcation of boundary of the AWC, the
Here,
residential
my lord,
status of the
boundary dispute
candidates
has been, my lord,
could not be ascertained.
my lord.
No, it cannot go on like that.
Lordship, 1/2 lesser land has been donated by the respondent number 8 for the Lordship to be set up the Anganwadi center.
Have you mentioned that somewhere?
Yes, affidavit is also declared, Lordship.
Where have you mentioned that?
This affidavit is this one, Lord.
Where?
They have no mention, Lordship. It is declaration by the affidavit, he is father, Lordship.
It's not part of your counter affidavit.
No, Lord.
No. You have not stated that in your counter affidavit. Then we can't consider that. You should have taken that stand in your affidavit that who says I'm an outsider? I'm an insider. My father donated this much land. You could have said that. Mr. Saikia, have you filed any representation?
My lord, I have not filed.
You have not filed. So you're not very serious about the objection. You've gone to the extent of filing a writ petition. You could have submitted one simple representation.
My lord, since the
See,
verification.
both of us are the only candidates. I am from this place. She's an outsider.
My lord,
Why did you take that? Why have you chosen this person? I should have been chosen.
since my lord verification.
One paragraph would have been done. You could have asked them to
Would have
look into
done.
it.
But since the verification has supported my case, my lord.
It has not supported your case. It has not supported anybody's case. It says that verification cannot be done. So under the circumstance, I don't think there is any case for interference. Because the basis of selection is on the basis of the village headman certificate. Which
And
is
that
not,
was- that
which
was
is not
submitted-
disputed by you.
That was submitted after, they have admitted, but after advertisement, they have submitted this certificate.
No, I've seen the records.
And now they have said, my lord, they have donated. If donation is the selection criteria, my lord, then I have nothing to say. my lord.
Donation, I am not taking into consideration. I already said that. That's why I asked him whether he had taken the stand in the affidavit. He has not taken.
But that's a
So,
real.
we will
real-
not consider
real fact,
that.
my lord, that has been.
We
come
will
up.
not enter into that aspect. But insofar as the certificate is concerned, you one is 2014, correct? But one is 2013. At the time of selection, she has submitted 2013. So we'll go by that only.
But it is their document, my lord. In the affidavit, they have filed it, my lord.
I'm disposing it off. Please write down. Heard Mr. P.J. Saikia, learned counsel for the petitioner. Miss M. Bhachaji, learned additional senior government advocate for the official respondents, and Mr.
PK Gogoi Lordship.
P.K. Gogoi, learned counsel for respondent number 8. Stop, next para. By filing this writ petition, the petitioner has challenged the selection and appointment of the respondent number 8 as Aganwadi helper. What is the name of the center? In number 2, Khojua Patir Gaon Aganwadi Center under the Dhakwa Khana ICDS project, Dhakwa Khana in the district of Lakhimpur. To stop, it is the case of the petitioner that the respondent number 8, being an outsider, would not have been recommended for appointment to the post of Aganwadi Center concerned. Stop, Mr. P.J. Saikia, learned counsel, referring to the final joint spot verification report dated 11/1/2011, submits that as per the said report, although the respondent number 8 secured the highest marks in the selection, but it was alleged that she is an outsider. And therefore, the committee suggested that proper verification in respect of the residence of the respondent number 8 be conducted to ascertain her residence. And pending such verification, the result should be upheld, should be withheld. Stop, next para. Thereafter, the respondent authority concerned floated a second advertisement on 8/4/2013 for filling up the post of Aganwadi helper in the said Aganwadi Center. Stop. Two candidates, namely the petitioner and the respondent number 8, participated. And in the selection process, the respondent number 8 secured the highest marks. And accordingly, she was recommended for appointment. Stop. The approval for her appointment was given via communication dated 1/8/2014. And since then, she is working in the said post. Stop. Next para. Mr. PJ Saike, learned counsel, submits that the respondent number 8, being an outsider, could not have been selected and appointed to the said post. And this fact can be seen from the report dated 19/1/2013 made by the state level screening committee prior to the issuance of the second advertisement on 8/4/2013. To stop, as per the said report, it has been opined that the DC's report revealed that due to non-demarcation of boundary of the Anganwadi Center, the residential status of the candidate could not be ascertained. To stop. The said report although not filed in the writ petition, is produced by Mr. PJ Saike today. Next para, Mr. PJ Saike, learned counsel, further submits that the respondent number 8 in the second selection process had submitted her residential certificate which was issued in the year 2014, while the advertisement was issued on 8/4/2013. Stop. Therefore, this also goes to show that the respondent number 8 is only an outsider. I said 2014, isn't it? I'll give you the proper date. No, residential certificate. That one, you write, instead of in the year, you write residential certificate dated 19/7/2014. Next para. The learned counsel further submits that the comparative statement annexed by the respondent number 8 and the one annexed by the respondent number 5 are not similar. Moreover, there appears to be one more candidate in the comparative statement annexed by the respondent number 8. To stop, he therefore submits that even on this ground, the selection of the respondent number 8 is doubtful, and therefore her appointment should be set aside. Her appointment and selection should be set aside. Next para, Ms. M. Bhattacharjee, learned additional senior government advocate, on the other hand, submits that there is no reason to doubt the residential status of the respondent number 8, inasmuch as the respondent number 8 inasmuch as the residential status of the respondent number 8 is duly supported by a certificate issued by the Gaumbura of 4 number Khajua Patir Lat on 24/1/2013. To stop, therefore, merely because the respondent number 8 had subsequently submitted a similar residential certificate which is dated 19/7/2014 for the purpose of filing the counter affidavit in the writ petition, her residential address cannot be disputed. To stop, she further submits that insofar as the comparative statement of the candidates is concerned, there is no discrepancy, as both the comparative statement in the affidavit in opposition of the respondent number 8 and the respondent number 5 are with the same marks. Stop, only difference is that the marks given by each of the members of the selection committee have been shown in the comparative statement annexed by the respondent number 5. And there is no reason to doubt the genuineness of the same otherwise. Next para, Mr. P.K. Gogoi, learned counsel for respondent number 8, adopts the argument of Ms. M. Bhattacharjee, learned state counsel, and submits that the respondent number 8 is indeed a resident of number 2 Khajua Patir, in which the Anganwadi center is located. To stop, he submits that although the respondent number 8 has not made a statement, but in her counter affidavit, but the fact is that her father had donated how much land?
1 kotha 2 lesa lot.
1 katha, 2 lesas of land for the establishment of the Anganwadi center. To stop, therefore, the claim of the writ petition is without any basis and the writ petition should be dismissed. Next para, I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. Stop. The issue regarding the residential status of the respondent number 8 has been questioned by the petitioner on the basis of the joint verification report dated 11/1/2011, wherein it has been recorded that although the respondent number 8 secured the highest marks, she has been alleged to be an outsider. Stop. Therefore, a suggestion was made that proper verification be done. To stop. Thereafter, whether joint verification was, no, whether proper verification was conducted or not is not discernible from the materials available on record. Stop. However, Mr. P.J. Saikia, learned counsel, has produced the minutes of the meeting of the state level screening committee held on 19/1/2013, wherein it has been recorded that as per the Deputy Commissioner's report, it is revealed that due to non-demarcation of the boundary of the number 2 Khajua Patir Aganwadi Center, the residential status of the candidates could not be ascertained. Stop. Therefore, the issue regarding verification of the residential status of the candidates concerned rest, R-E-S-T, rest. At that only. To stop. However, in the selection process that was initiated pursuant to the issuance of the second advertisement on 8/4/2013, the candidates concerned produced their relevant documents, and that an interview was conducted on 29/6/2013. Stop. In the process of the selection, the respondent number 8 had submitted a residential certificate issued by the, who has issued this? Mr. Counsel, who has issued? Private counsel?
Village headman, my lord. Gaonbura.
Issued by the Gaonbura on 24/1/2013. To stop, the screening committee / selection committee, upon perusal of the documents concerned, on being satisfied, recommended the name of the respondent number 8 for appointment as Aganwadi helper for the said Aganwadi Center. To stop. Therefore, in the absence of any materials to the contrary, and importantly, a challenge to the Gaonbura certificate issued in favor of the respondent number 8, this court is inclined to accept the same as to show that the respondent number 8 resides within the Anganwadi Center area concerned. Stop. Insofar as the discrepancy pointed out by the learned counsel for the petitioner on the comparative statement of marks, comma, it is seen that there is no difference in the total marks given to the candidates. Stop. One of the comparative statement provides for the aggregate marks obtained by the candidates, and the other provides for the breakup of marks by showing the marks allotted by each of the members of the selection committee. Stop. Therefore, the marks allotted to the candidates in the considered view of this court being the same, the comparative statement annexed in the affidavits cannot be doubted. Next para. Upon due consideration, this court does not find merit in the writ petition. Accordingly, the same is dismissed. No cost.
Highly available. Tolerable.
The review petition.
Hmm.
The government had to place some instructions.
BTC,
Petition.
Mr. Chisti was there earlier. Today, who's there?
Lordship,
The same instruction is here.
Lordship, may I place the updated instructions here, Lordship?
Regarding the
Regarding the.
sanction,
Lordship, the creation.
has it been sanctioned?
Not
And the
yet, your
qualification of
Lordship.
the inspector.
Not been sanctioned, your Lordship, because, Lordship, it has been enclosed, your Lordship, that. Lordship.
The enclosure is dated 7/10/2024.
7/10.
Where is that copy?
7. Lordship, I have mailed it, so can I take it?
Yes. What do you understand by this letter?
Lordship,
You have
we are
read it?
seeking
You have read
further
it?
clarifications, Your Lordship, as to what will happen to the post, what will happen to the existing headmasters and the assistant headmasters, Your Lordship.
It says, I am directed to request you to clarify / propose the arrangements to the headmasters and assistant headmasters if they are found not qualified to hold the post of principal and vice principal.
Because, Your Lordship, what earlier the instruction was that that instead of creating new posts, what the government had proposed was that the existing post of headmaster, assistant headmaster, they will be upgraded to the post of principal or vice principal. So since it will be upgraded, Your Lordship, so what will happen to the existing headmasters and the assistant headmasters? So they have sought clarifications. If we upgrade the post, so what will happen to them? Because if they do not qualify, because some headmasters may not have the required qualification that is required for the post of principal and assistant vice principals.
What is the qualification otherwise?
It's at Rule 12.
What is the difference of qualification?
Page 118, Lordship. Page 118.
Which says, what does it say?
It's age of 40 and more, and BEd, MA, BEd qualification, then 17 years of teaching experience. as
For principal.
graduate, For principal.
For principal.
For principal.
Above 40 years.
Above 40 years, as far as I remember.
And for headmaster?
Master is the same. That's page 118. See, I have annexed rule. The minimum qualification requirement for the post of principal in high secondary multi. The post of principal in provincialized high secondary schools and high secondary and multi-purpose schools shall be filled up by direct recruitment. The minimum qualification for appointment for a post of teacher, the candidate must be MA, MSc, BEd from a recognized university having uniform good academic career. The candidate must render 15 years of service as a postgraduate or vice principal or both in the provincialized high secondary. The candidate must have 17 years of teaching experience as graduate teacher in any high secondary multipurpose school. The candidate must not be less than 40 years as on the 1st January of the year of recruitment. What I submit is that apparently from the page 103 also, and the petition filed by the respondent, I am senior most with the qualification. The court which by its order which is under review just made a temporary arrangement on the submission of the state respondent that it will be sanctioned, and the finance department is pursuing it. And Lordship, none of the parties brought to the notice of the court the judgments that have been annexed, Lordship. Therefore, Lordship, till if the post is sanctioned and created or some other arrangement is made, Lordship, I being the senior most and qualified, I may be allowed to hold the principal in charge, Lordship. That is my submission.
Clarification was sought sometime in October 7th.
Lordship, some time may be given, Your Lordship.
So you may wait for some time, I
Lordship,
think.
Lordship,
That's what I feel.
Lordship.
We'll post it again after 3 weeks.
Lordship.
Let something come up. Let's see. Please write. Mr. DP Boran. BP Bora, learned counsel, appears for the review petitioner, while Miss
D. Musahari,
appears for the
secondary education.
secondary education. And she produces 2 communications dated 7/10/2024, written by the Deputy Secretary to the Government of Assam, Department of School Education to the Director of Secondary Education, Assam, asking for certain clarification. Most of the other letter is written by the Secretary to the Government of Assam, Department of School Education to the Standing Council, Department of School Education on 4/11/2024, stating that since some clarification has been sought from the Directorate, the proposal to be submitted to the Government of Assam in the Finance Department is put on hold. Stop further, once the clarification is sought, clarification sought for is received, the matter will be put up before the government for approval. Next para, considering the above position, this court deems it appropriate to defer the matter to be considered after 3 weeks. The communication dated 7/10/24 and 14/11/24 produced by the Learned Standing Council, School Education Department, shall be placed on record, marked as X and Y. For identification. 3 weeks or 4 weeks?
Also 4 weeks.
We'll make it 4 weeks. The Learned Standing Council shall inform the court about the up-to-date status by the next court date.
Obligation.
Yes.
Lots of, sorry, on the other day, I could not be remain very much. Lots of, I have got the instruction, and this is the order of this honorable court is going to be complied, lots.
When?
Lots of the, within the thing is that the code of conduct is on in Biswanath district, lots of there, because of that, some decisions cannot be taken. So after the code of conduct is over, also on 23rd of November, let's say, the decision that is
Any election coming up?
yes, lots of by-election is going on.
By-election.
Lots. So I have got all the instruction. Recently, the petitioner has submitted another representation annexing certain documents that was sought for by the executive officer, Biswanath Municipal Board, lots, on 24th of October, lots. So now the communication and between the petitioner and the contender is complete, lots.
But you must see, the
Yes,
order was
lots.
passed in the year 2022.
Yes, lots.
Model Code of Conduct came only yesterday.
Lots.
I know the instruction may be placed as a record in the code, your lordship.
I have got the instruction. These are the written communications between the petitioner and the respondent number 2 lots. In between the respondent number 2, incumbent of the respondent number 2 also got sent. So, but the active consideration is going on. Lots of may give us fix the matter in the last week of this month. Everything is going to be complied.
Okay, we'll give you a date then.
Lots of
last week of this month means 27?
yeah. Lots of can you make it 28?
Your good name?
D Das.
Mr. D Das, Learned Counsel for the respondent number 2 submits that the order of this court will be complied with. But however, in view of the enforcement of the Model Code of Conduct on account of the by-election
Bihali constituency.
in
Bihali constituency.
Bihali constituency,
In the district of Biswanath.
Biswanath Chariali district, necessary steps could not be taken to stop. He otherwise assures that if the matter is listed by the end of this month, he will get back to the court with the instructions about the compliance of the court's direction. Stop next para, Miss. Your good name, Miss
ST Bakt, Your Lordship.
SK
ST Bakt.
ST Buck,
Buck.
learned counsel, appears for the petitioner. In view of above, let the matter be listed again on 28th of November 2020.
29, Lordship. I'm just looking through, going to the 25 calendar, Lordship. It would be a Friday, 29.
That is the last working day. Okay, 29th of 29th of November 2024.
I'm almost.
Oblige, Your Lord.
May it please, your lordship. Lordship, may I kindly see the last order, lordship. That is 12/9/2024, lordship's order. So actually, thing is that lordship, the issue is already being pending before the division bench, lordship. So, and yeah, the division bench matter it came out in the month of September, lordship, and the counsel for the petitioner he paid for some time.
What is that matter? Case number?
Case number is WPC. It's the WPC, lordship, 646 of 2019.
646.
646 of 2019.
What is the issue involved?
Issue involved is that, lordship, these petitioners are from BRO, lordship, and they are claiming RNP, recruitment and promotion benefit that as per lordship, there are other military department under Government of India, lordship, CISF, CRPF. So, lordship, they are claiming benefit as per the RNP rules of those department, lordship. So, in our affidavit, we are saying that, yes, we are saying, we are saying that we have separate.
Sorry, my lord, I totally missed the matter today, my lord. And in fact, my lord, according to his submission made on the earlier occasion, there is a matter, similar matter pending before the division bench. And he said that that judgment would cover this case also. I'm not sure whether that has attained finality.
No, that has not attained finality. That is the instruction of my client. And also I have consulted the DSGI in that regard. DSGI also told that it is a same. So let the matter be disposed of in the
WPC 646 of 2019. That is the similar matter. Just pending. Before division bench, you say.
division bench, lordship.
So my lord, can it be taken up after disposal of that matter? Because the division bench judgment would cover this case. And if otherwise lordship thinks that lordship would proceed with this matter, can it be taken up on Monday or next Thursday, my lord? Today I missed the matter, my lord, honestly.
No, if it's going to be covered by that judgment, then I think we may await. Otherwise, that is why it was adjourned last time also. Please write down, parties are represented by the respective counsels. Stop. It is submitted that WPC number 646/2019, which is a similar, wherein a similar issue has been raised, is being considered by a division bench of this court. And therefore, the instant writ petition may be deferred pending final disposal of the said writ petition. Since it will squarely cover the present case as well. Just add one there, since the outcome, put that, add, since the outcome would squarely cover the instant case. In view of above, the matter stands deferred for 3 weeks, 4 weeks?
4 weeks, lordship, 4 weeks.
4 weeks.
No, sir.
I'll come back in 5 minutes.
So in this matter, petitioner has challenged the gradation list. Lordship, all the two petitioners and the three private respondents all has already been retired, Lordship.
The petitioners and the private respondents have retired, all of them.
All five. Two petitioners and three private respondents.
And the gradation list is for what purpose?
Lordship, for
For the purpose of
promotion.
seniority and promotion. Now, even after retirement, supposing they were supposed to get promotion at the relevant time, were not granted, that notional promotion, can it not be given? Will become infructuous if they retire.
They have paid for a promotion for retrospective effect. For that, Lordship, we we want the record from the department. Actually, record is not yet found out, Lordship. We need 2 weeks more time if we produce the record to clear that whether this.
All right, you take 2 weeks time, no one is there for the other side also. How come there's no one? Who are the counsels? This is item 14, isn't it? To comply with the order dated 25/7 in producing the record. Okay, this is what. None appears for the petitioner when the matter is called as paid for by the learned. Your for respondent number?
On to respondent number.
Betty.
1 and 4, Lordship, Animal Husbandry and Veterinary Department.
Learned Standing Council, Veterinary, Animal and Husbandry and Veterinary Department. Further 2 weeks time is granted for producing the relevant records. Yes, next.
Obliged.
Yes.
May it please your lordship. Your lordship, this relates to the petitioner herein was appointed as a accountant cum assistant block program manager in the NIHM on contractual basis in the year 2008. But that used to remain extended every year. And there was also promotions, policies and everything. And finally, the petitioner was promoted as block program manager. So what happened in 2016, there was an allegation that funds have been overdrawn by the ASHA workers. Now, ASHA workers are the ones who works in the field and they submit their bills. And there is a chain of peoples who looks, verify. I am only the disbursal authority. I have just, if your lordships kindly takes up the paragraph 7 of my affidavit. 7 of my writ petition. Page 7, para 7. Has the lordship got it?
Yes.
That the petitioner respectfully begs to state that the petitioner was responsible to disburse the payments of the various staffs of the National Health Mission after the verification of the same. That the petitioner respectfully begs to state that during the particular period, the amount of the incentive paid to the ASHA workers was paid in excess of the actual payment that was required to be paid. But the fault could not be attributed to the petitioner as the bills were prepared by the ASHA workers, which were duly verified and forwarded by the ASHA supervisor, then AVPPM, then ANM, and finally by the sectoral in charge, and was forwarded thereafter to the petitioner for payment. It needs to be stated herein that the payment was credited directly to the registered bank accounts of the ASHA workers and was not paid in cash. Now the next para, your lordship, wherein the problem started. That the petitioner respectfully begs to state that thereafter the petitioner was informed by his superior officers about the excess payment being credited into the accounts of the ASHA workers under Srijangram BHPC, and accordingly, the petition immediately started to recover the excess amounts so credited to the accounts of the ASHA workers, Srijangam BHPC, while later dated 27/10/2016, intimated the same to the Joint Director of Health Services, while later dated such and such. Your Lordship, the issue is like this. They prepare the bills are being verified and forwarded to me for disbursal. My status is that of an accountant. I look into the bills, whether that has been verified by my superior officers or not. And then I release the bills. In the bills, they are stated to be, there is a direction for me to clear the bills. Somebody may have prepared the false bills, or somebody might have prepared the bills in a exaggerated amount. But I am not supposed to look into that. I am only to follow the instruction given by the superior officers, which I did. Now, when I realized, when this came to me, my superior officers intimated me that you have credited the amount in excess, what they are actually required to be paid. I immediately started recovering it from the next bills, which is there in the account. Now, all of a sudden, without any notice, without anything, I was discharged from the service. There was no disciplinary proceedings, nothing. Now, they say that there was an FIR register, first count, that there was an FIR that was registered in the police station. I took a certificate from the police stations. I inquired about the FIR. The police station informed me that there is no FIR against you, first of all. Secondly, they say that in the performance appraisal, I was given E, grade E. But the fact remains that it is my categorical stand that I was not allowed to fill up the performance appraisal form. And secondly, I was not called for the interview. And
Which interview?
when I need to fill up a form, they say that my performance appraisal is E, and therefore I am not continued in the service anymore. But my specific contention is that to give me a grade, say A to E, whatever grade they desire, on the basis of my appraisal, I had to fill up a form every year, which was not allowed to be filled up by me, and I was not called in the interview. So how could they unilaterally come to the conclusion that I am being allotted with grade E, and there was an affair?
This regarding interview, which you mentioned.
Yes, Your Lordship.
To fill up the appraisal form and thereafter interview is required.
Yes, Your Lordship. To call me to require, that's the process, Your Lordship. Every year, because this is a contractual appointment, my contract will be renewed only on the appraisal form being filled up by me and satisfactory performance of my work. But
And for that satisfaction, you have to be interviewed.
yes, Your Lordship. That's my instruction.
I see.
But you have unilaterally.
But unilaterally they've given you a grading of E.
Yes, Your Lordship.
E means what? It's bad.
It's bad, Your Lordship. Their gradings
How,
are
how is it given? A to E.
A to E.
A, B, C, D, E. 5 gradings.
Yes, Your Lordship. They have given me E, and they have not continued with my service. And the most importantly, Your Lordship, now what my basic point is that there was no inquiry against me. If there was an inquiry, the report has not been furnished to me. Secondly, the Supreme Court has said in BRPL cases, in GC Sharma and BRPL cases, that when the entire chain of events, when there are a lot of people involved, it is not possible to pick up one fish and say it only stings. I have categorically stated that there are many other people who are responsible to prepare the bills, to forward the bills, to verify the bills. I am only the disbursing authority.
Okay, you are a contract appointee.
Yes, Your Lordship.
Now, what is the what is the spell of your service at one go? It is to be renewed every year or after every 2 years or every 3 years like that?
Initially, Your Lordship, I was appointed in the year 2008. Then it was renewed, Your Lordship, in the year 2011. Till 2011, it was renewed, Your Lordship.
Every year?
Sometimes every year, sometimes twice in a year, sometimes twice in a year.
And when was the last before you were released?
Your Lordship, I was appointed, I'll just say one thing. Your Lordship, if your Lordship kindly comes to page 22.
Yes.
Has your Lordship got it?
Yes,
Annexes
yes.
to page. Point number 5.
Hmm.
Notwithstanding anything contained herein above, the services of the party may be terminated at any time of the society if the party is found to be guilty of any insubordination, intemperance, or other misconduct or breach of non-performance, it being clearly understood that the society shall always invoke the clause in consultation with the chairman of the society and member secretary of the society. Number 7, either of the parties here to have a right to terminate this agreement without assigning any reason, provided with a written notice of 1 month is given to the other party. Both the parties may, in lieu of the written notice, give other party a sum equivalent to the amount of the salary or month or shorter notice of 1 month, and the sum equivalent to the amount of his pay or the period of which such notice falls short of 1 month. The tribunals at Guwahati, courts in Guwahati shall have the jurisdiction. Your Lordship, but it depends on the satisfactory performance appraisal, Your Lordship, that they will continue with me.
So your service details is not there.
No, Your Lordship.
Page 49 is the release.
Yes, Your Lordship.
That was on
That was all it was stated, and I was
20th
not.
October 2017.
Yes, I was not paid my salary, Your Lordship, because of this inquiry for a period of 1 year, Your Lordship. From 1/11/2016 to 4/1/2016, I was not paid my salary, although I continued in the work. So this, in my humble submission, this release letter is, Your Lordship, is liable, is bad in law on the face of it, because they say this is to inform you that you have secured grade E as per the result of the review of performance appraisal of DPMU staff for 2015-16 by the mission director, by dated such and such, dated such. But they have not produced any records to show that I have been awarded performance appraisal E on the basis of their some performance appraisal they have done. They have simply given me E.
So from November 2016
Yes, Your Lordship.
to October 2017, you were working,
Yes, Your Lordship.
but no salary.
Without salary.
Hmm.
No,
I'll
I have
check.
been working without salary till 4/1/2017. Because
4/1.
Yes, Your Lordship.
How is that?
Because Your Lordship will kindly come to page 45.
45.
I was released on 4/1/2017. This is the letter. With reference to the subject cited above, this is to inform you that you are being temporarily discontinued. It was initially temporarily discontinued, as the capacity of BM Sri Changram BHPC due to an FIR. The Lordship will kindly mark this, due to an FIR has been launched against you on date 28/10/2016, and accordingly, Mr. Jadhav Ray, DHS Boyagaon, has been temporarily attached as the capacity of such and such. Now, Your Lordship will kindly come to page 50. They say that an FIR has been lodged against me, therefore I have been temporarily discontinued. Now, page 50 is the police report, Your Lordship. Has Your Lordship got it?
Yes.
Certified that I have consulted with available PS records, but found nothing, any criminal case has been registered against Wasim M. Parvez, son of such and such and such and such. This refers to the Abhayapuri police station, such and such number. So there is no police station case, no police case pending against me. So on the face of it, it's bad in law, Your Lordship. They have temporarily discontinued me on 4/1/2017 on the plea that there is a FIR against me. In their affidavit in opposition, they could not bring on any records, any FIR which is against me.
Right.
Neither any action has been initiated against me, and on the basis of this, Your Lordship, I was released.
You were released on 4/1/2017.
Temporarily.
Since they are not functioning, isn't it?
Yes, now they finally released me on 20/11/2017, saying that my performance appraisal is E. Yeah, Lordship, otherwise in the service matter, what is there? It is only we are not on the decision. Of course, we are on the decision, but it is a procedure. In the service matter, there is nothing left except the procedure that need to be followed. If the procedure is bad, Your Lordship, everything goes.
So what is the service detail? Not possible. Find out. 4/1/17 you were released.
I was temporarily discount. No, Your Lordship will kindly mark.
No,
I was
temporarily discontinued.
on the plea that an FIR. Where is that FIR?
No, there
Where
is
is
a
that FIR?
that will come to that.
Yes,
You continued till 4/1/2017.
correct, Your Lordship.
Then thereafter you were finally released on 2/11/2017.
Right, Your Lordship.
So according to you, your pay salary has not been given since November 2016.
16 to 4/1/2017.
And the incident of these happened when did this happen? Discovery of all these
Your Lordship, discovery of all this happened.
in November.
Yes, Your
16.
Lordship. It's somewhere happened in October, Your Lordship. I'll just come to that.
Okay.
Annexure 8. Now the SDM writes to me, Your Lordship. Page 37. Has Your Lordship got it?
Yes, yes.
I have the honor to inform you. It was written to the Joint Director. I have the honor to inform you that an excess amount of payment of ASHA incentive has been done to different ASHA under Srinjangam Block PHC. Write all documents of ASHA forwarded by Block Accounts Manager of Srinjangam section, AMO such and such supervisors. The excess payment, particularly in spacing of birth and family planning program, is made through genuine documents duly forwarded by all sectorial officers. The major part has been already recovered with due permission of the beneficiary of all. Your Lordship will see the SDM write to the Joint Director that the excess payment, particularly in spacing of birth and family planning program, is made through genuine documents duly forwarded by the sectorial official. The major part has been already recovered with due permission of the beneficiary and all. So I'm not the person, I'm been made a scapegoat.
What is this ASHA full form?
Your Lordship, ASHA, by the few ASHA full forms. By the these are, I'll just say, these are like workers who travel to doors, just like polio, then the birth control, and to see that whether there is any pregnant lady in the area who needs to be educated, that how they need to feed themselves, they need to take care of themselves. They're basically working in the field. Now, I don't know, Your Lordship, there are some health workers. Basically, they're health workers who roam from door to door to see whether any polio was to be given in the village area. Basically, this has been taken care of. These are under the National Health Mission policies.
So they are given
Some
certain
incentive for the duties they're rendering.
So that incentives happen to be in excess.
Yes.
And you have been made the responsible for that.
Yes. Now the incentives has been the bills they prepare. Now there is a chain of incidents.
No, that I've understood. There are you are somewhere on the.
I am only the dispersal authority. I am the accounts officer, Your Lordship.
So the bills are prepared, checked, everything. It goes
Verified.
through various stages.
Yes, Your
you come
Lordship.
at the ultimate stage only.
Correct, Your Lordship.
So that's why you cannot be given that fix the what do you call the burden. That's what you're saying.
Made the person to be responsible for that dispersal.
No, that I've understood. Accredited social health activist.
Yes, Your Lordship.
ASHA.
Yes, Your Lordship.
Now, thing is that the question which I wanted to pose you had already mentioned some time back. Why I was asking you about your service detail is that you are not a permanent worker. You are a contractual employee.
Yes, Your Lordship.
So you're governed by a certain contract that you work for 1 year, 2 years, 3 years like that.
Yes, Your Lordship.
Now, no matter or to what extent or whatever it may be, procedure has not been followed. Even if we rectify all that, try to rectify, what gives a right for you to get back to your post?
Yes, Your Lordship.
That is the ultimate goal which you are looking
Right,
for,
Your Lordship.
to get back into the post.
That is a pertinent question that has fallen from Your Lordship. I'm obliged. In fact, a division bench has passed an order to that. Ultimately, Your Lordship, Now your lordship will relate back to this in the month of January 2017, 4/1/2017. Had I not been released on this plea, I would have continued in my job like my other colleagues till today.
Till when?
Till now, in fact, they are continuing.
No,
till
no,
now.
no. See, you're a contract employee. That's why I just wanted to know. You yourself had said that 2008 you started.
Yes.
It was extended from time to time, 11,
Yes.
9, 10, 11. Then 17 you were there.
Yes, your lordship.
So what was the last
Yeah.
extension?
No. It was extension used to be done on the basis of the performance appraisal from I used to fill up every year. In fact, your lordship, all the employees of the NHM are contractual, your lordship.
No, that's why. No? You show me one extension order. Is it not available here anywhere?
No, your lordship, it's not available here. I'll just place one judgment before your lordship.
See, the factual aspect we need to clear out.
Yes.
We need to thrash out the factual aspect before we go to the law
Yes,
or the authorities which you want to rely upon. So your particulars should be clear. 2008, you started as an accountant. Thereafter, you were given the charge of
I've been promoted also, your lordship.
promoted
Yes, sir.
BPM. Block,
Yes.
what do you call that?
Block accounts manager, your lordship.
Block accounts manager.
Yes, your lordship.
What is that? What is PM, BPM?
BPM
Block
is block program manager, your lordship.
program manager. That's
Yes,
what
sir.
you said.
Yes,
Yes,
sir.
block program manager. Is it above the accountant?
Yes, your lordship.
Above the accountant.
Account.
As a block program manager, what are you supposed to do?
No,
To
your
verify the
lordship,
bills or to
my job was only to disburse the bills which comes to me.
disburse the bills?
Yes, your lordship. That, and with the authority that you are required to disburse the bills.
You are the DDO. Are you the DDO also?
No. I was just, my job was like an accountant, your lordship. I released the bill. That's it.
By affidavit, the responsibilities is
Okay. We'll come to that. I just wanted to know briefly what is the background.
In fact, all the persons who are working in the NHM are all contractual.
All contractual, correct? Then the FIR, they say that by which your service was discontinued temporarily. You have gone and obtained a certificate from the police station concerned.
Yes, your lordship.
One police station. What about others?
No, your lordship, it was under, no, I'll just point that out.
Abhayapuri.
No, it was under your lordship. I was under that Abhayapuri police station that at that moment of time at Gwalpara. So there was no, in fact, they could not also produce any FIR, your lordship, in the affidavit. And they have not uttered anything. What is the case number? What is the police station? Anything, your lordship. I have categorically denied it on my affidavit on oath that there is no FIR against me.
What is the response?
They have not responded to it. Neither they could bring any FIR, copy of the FIR on record by an affidavit, your lordship.
Regarding your police report, they have not
Yes,
said
your
anything.
lordship, nothing.
They have not said anything.
They have not, they could not bring anything on record to substantiate their claim and to counter the statement made by me that there is no FIR against me.
So your pay remains as an area till now.
Yes, your lordship.
And the writ petition was filed in 2018.
18. And your lordship, the performance appraisal and the basis of which they discontinued me could not have been done. So this termination is bad in law, in fact, your lordship.
But you are employed elsewhere now, probably.
Huh, your lordship? I could not.
You are employed elsewhere now, probably.
No, I'm not.
In a
I'm
better
not
job.
employed anywhere else, your lordship.
You're not
That's
employed.
Not.
Okay.
In fact, if your lordships allow me, I'll just non-renewal of the contract part, a division bench of this honorable court has passed a, or if your lordship kindly peruse the same.
With liberty. Join back with liberty. Is that the order?
Yes, your lordship. But no, I'll just go through it. Para 7, page 4, it's down below left side, page 4, your lordship.
Yes.
I'll read the facts, therefore it will be clear, your lordship. Mrs. Saiwala has argued that though the impugned letter 11/12/2009 communicated with inquest decision of non-renewal of the term of the appointment of the appellant as BPM, it is apparent from the pleadings of the respondent that the same in reality was a punitive step against him. as the said action has been taken against the appellant without affording him any opportunity to represent against the adverse materials taken note of by the respondents, it is liable to be set aside on the ground of violation of principle of natural justice. The learned senior counsel has argued that as the appellant continued beyond the initial contractual term, there was no scope of non-renewable thereof, and the imputation is palpably one of the termination is appointment as BPM. While contending that due to the continuous and unstinted performance of the appellant in Kachugodam PSC, of which he was a BPM, had been judged second in the district of Karimganj, Mr. Saiwala has urged that only all the members of the performance appraisal committee were not present during the proceedings held on 26/6/2009. The imputation has been taken leaving out the consideration of the relevant materials in favor of the appellant and acting on the impediment facts against him. In this regard, the learned senior counsel in particular has drawn the attention of the court to the report of the such and such, as well as the representation of the members of the local institution, appreciating the role of the performance of the implementation of the projects of the National Rural Health Mission Assam in concerned area. Reliance have been placed. Thereafter, next, I'll skip that paragraph. No. Paragraph 8, Your Lordship, then. In reply, MS Verma has maintained that as enjoined the performance of the BPMs and the block accounts managers were apprised in terms of the norms formulated therefore as on 26/6/2009 by the Performance Appraisal Committee. According to her, though the petitioner made his presentation before the said committee on that day, his performance was not up to the mark and the committee on evaluation therefore, as well as overall activities in the capacity of union, recommended against renewal of his contractual terms in that said capacity. I'll pause here for a moment, Your Lordship. I have categorically stated in my writ petition that I was not called for the interview. This lines goes to shows that there is some interview, the persons are called, because it says that on reversion of the, according to her, though the petitioner made his presentation before the said committee.
No, this is under the same establishment?
Yes, Your Lordship. Line 4. According to her, though the petitioner made his presentation before the said committee on that date, his performance not up to the mark and the committee on the evaluation therefore, as well as the overall activities in the capacity of BPM, recommended against the renewal of the contractual appointment. Now, my case is that you have done my performance appraisal at my back, which you could not have.
This is also a case regarding block program manager.
Yes, Your
Under
Lordship.
the NHM.
Right, Your Lordship.
Okay.
Highlighting the adjournment of the Kachugudam PSC to the second in rank in the Karimganj district is it's per se not demonstrative of the appellant's level of performance and his capacity as a team leader. The learned standing counsel has dismissed the cavil against the denial of opportunity to him to explain the materials on which the imputation was eventually taken. MS Verma has argued that the appellant was accorded all reasonable opportunities of making his representation before the Performance Appraisal Committee and that therefore his challenge to the impugned order on the ground of unfairness in action is unsustainable in law and on facts. Your Lordship, they have not stated anywhere that I was given the opportunity to present my performance before the appraisal committee. She has claimed that the impugned decision has been taken in terms of the contract. The learned standing counsel has apprised this court on the measure of the performance assessed by the committee. The contractual term of many BPMs, BAMs like the appellant has not been renewed. On being queried by this court, she has submitted that the Deputy Commissioner and the Joint Secretary of the Health Services are respectively the chairman and such and such. Now the observation of the court. We have duly considered the pleadings on record as well as the submission made that the appellant has continued beyond the initial period of 6 months of his contractual appointment as BPM in the matter of record. The affidavits filed on behalf of the respondents make it apparent that the abuse decision had been taken as contemplated in clause 8 of the contract executed between the appellant and the Joint Director of Health Services come such and such. It would be apparent from the said clause as extracted herein above that the services of the appellant could not have been terminated by the society if he was found termination period 2 has been apparent as extracted herein above that the services of the appellant could be terminated at any point of time by the society if he was found to be guilty by his insubordination, intemperance, or other misconduct, or of any breach of non-performance, and that it could be invoked in consultation with the chairman of the society. Para 10 of the affidavit filed with the respondent number 2 clearly reveals that the appellant's contract was terminated for non-performance, insubordination, and corrupt practice as per the clause 8 of the terms of the contract based on the performance appraisal report. It is thus obvious that impugn decision had been taking note of the appellant's non-performance conduct of insubordination and involvement in corrupt practice coupled with the performance appraisal report laid by the committee. It is apparent as well as para 7 of the said affidavit that the performance of the appellant was found to be unsatisfactory on the account of poor team spirit and such and such. Now the last line, the performance appraisal committee ascribed E grade to him, which was below average. The deficiencies in his performance as a capacity, the deficiencies in the performance of the capacity of BPM as assessed in the realm of the team spirit, idea and involvement in HMIS, coordination with block level health functionaries, though have a bearing on his overall suitability. The imputation of the insubordination corrupt practice is apparently stigmatic. The records contain two sets of representation for and against the appellant, one highly appreciating his role and activities as BPM, and the other accusing him of gross defaults and malpractices. The report of the SDM and HO Kachugudam PSC, however, certifies his excellent managerial skill and remarkable contribution as BPM's in furtherance of the National Rural Health Mission project in the locality of his primary health center. The respondents in their affidavit admitted that the report of the SDM and HO Kachugudam PHC was not taken into consideration as the said authority was neither a member of the performance appraisal committee, nor was such report called for the deputy commissioner, come chairman of the District Health Society, Karimganj. In our considered opinion, having regard to the grounds on which the appellant's assignment as BPM has been terminated, he ought to have been confronted with the materials bearing on the accusation of his insolvent conduct and corrupt practice. Though the participation of the appellant in the proceedings of the performance appraisal committee dated such and such has not been denied by him, it is not very clear as to whether the inputs in general as well as pertaining to his conduct of insubordination and corrupt practice were made known to him for his response. We therefore do not feel persuaded to conclude that the impugned action having regard to the grounds cited in support thereof is sustainable in the facts and circumstances of the case. Though the appellant has been appointed as BPM initially for a period of 6 months, admittedly on the expiry thereof, he continued in capacity for the intents and the purpose the stipulations contained in the contract initially executed on 4/6/2007 subsisted on the date of termination thereof. In our view, having regard to the preconditions embodied in the clause 8 of the contract, no uncontrolled or unregulated power for the exercise thereof is conferred thereby, and the invocation of the clause has to be essentially in conformity with the basic tenets of fairness in action. The facts that the appellant has been offered 1 month's pay does not absolve the responsibility authorities of this obligation in law to ensure validity of the action contemplated in action clause 8. We are therefore in general agreement with the proposition of law laid down by the authority cited at the bar. The impugned order of termination is thus interfered with, having regard to the office held by the appellant with the deficiency indictments against him, who refrained from directing his reinstatement as BPM. This is more so as the interference and the impugned decision has been on the ground of fairness in action. So I stand on a better footing than this, Your Lordship. Here is a case where the person was allowed to be present before the performance appraisal committee.
So what happened? The ultimate result was that the reinstatement was not directed, and instead,
he was allowed
respondents
to.
would offer all reasonable opportunity to the appellant to represent against the ground on which impugned order of termination is issued, and thereafter take a decision on the issue, and the process to be completed within 2 months. That was the direction. What is this particular clause 8?
Your Lordship, clause 8 was in that case. Here will be clause 7, Your Lordship.
Either of the parties have the right to terminate.
Yes, Your Lordship.
This is the one.
Yes, Your Lordship.
Without assigning any reason thereof, provided written notice in 1 month, so and so. In lieu of written notice, given the sum of equivalent, so and so.
সেইটো প্ৰথমত ইনিচিয়েলি কিমান দিনৰ কাৰণে কৰিছে, তাৰপিছত আৰু কন্ট্ৰেক্ট কৰিছে যদি ৱাচিং বুলি আছে। I stand on a better footing. The reason is that it is my categorical stand. First of all, your lordship will appreciate the fact that the first incident which shoot up the entire issue, they say that there is an FIR against me. Now, where is that FIR? So you discontinued me temporarily from the service on a ground that does not exist at all. Because there was no FIR. Neither you could have demonstrated, neither the respondent could have demonstrated any FIR being lodged against me on an any allegation. That's the first thing. Secondly, they say that I have been given grade E in performance appraisal. My specific stand is that neither I was allowed to fill up the form, which I'm required to fill up, nor I was called for the interview. And there was nothing on records to show that I had filled up the form duly signed by me. The form is required to be in their custody.
What do you call that?
Performance appraisal form.
Performance appraisal form.
Appraisal form, your lordship, which they could not produce. Of course, they have given me grade E. And the third thing is that if there is someone who is guilty, then you cannot pick up one fish from the chain of people, from the group of people, to say that only this fish stinks. So the very root cause on which I was discontinued is flaw. As having a flaw in there, the entire thing goes, your lordship.
Generally, this performance appraisal
Yes, your lordship.
is initiated by the employee concerned.
Yes, your lordship.
He'll fill up whatever is there, whatever work he has done, he will
Yes.
go to the next level,
Yes, your lordship.
third level like that.
Yes.
Reporting.
The committee will call me in the interview. They'll check my entire credentials of my work, of my job profile, what I've done the last year. And on that basis, they'll give me the gradings.
Gradings.
Now, if ABC, I'll continue. That was the basic benchmark to test whether the persons are to be kept or not.
So here is a case where they have graded you E. And
Without going into my performance appreciation.
And you don't know how you have been graded as graded E.
Yes, your lordship.
And on what basis?
Right, your lordship.
You were not called for interview or
Right, your
all that.
lordship.
And you have not even initiated the appraisal.
Exactly, your lordship.
Okay.
Neither they could produce. That's my specific case, and that's the specific stand I've taken in my writ petition. Today they have said, no, we have given him. How we have given him? Where is the records?
The impugn letter doesn't say about the FIR ultimately, isn't it?
Right, your
It
lordship.
just says grade E.
Right. Your lordship, you'll see the initial cause is that there is an affair. And the final cause on which they release me is the performance appraisal form is not up to the mark. So there is no affair against me on the day when you have temporarily discontinued me in the office. And secondly, I say that I was not allowed to fill up the form, neither I was called for the interview.
And to which they don't say anything on it.
Nothing, they could not
Okay.
produce anything.
Okay.
There is a denial by them. But to substantiate that denial, they could not produce anything. And ultimately, a writ code is a code of records, your lordship. This code will go by the records, whatever is there. So my humble prayer is that this release order needs to be set aside, as it is bad on the face of law, face of it, your lordship. And further, I need to be paid my salary, and they may be directed to put me into the service back from that date. It will not be possible to put me from back that date or to give my back wages, but at least from this date, your lordship. Because the very reason does not exist at all, your lordship.
So that's your case?
Yes, your lordship.
All right.
Subject to what my friend says.
Yes, madam.
file my affidavit in opposition, my lord, on behalf of respondent number 6, my lord.
6. How many respondents are there in all? Who's the main respondent?
8, my lord.
6 joint director.
Joint director of health.
This is a employment is under the NHM, National Health Mission. So what about this 2 and 3?
2 and 3.
Impugn order is passed by which authority?
3 also, my lord.
In fact, my friend can represent everybody, your lordship, from 1 to 9,
1,
except the deputy commissioner, I suppose. 1 to 3, 5 to 9.
1 is principal
One is health.
secretary.
I'm not presenting NHM, my lord, 2, 3, 2, 3, 6, 8 and 9. 8 and 9.
7.
7 health.
7 no are.
But 6 is also health, joint director, health services.
Joint director come member secretary of district society, that is represented by National Health Mission.
Okay, you are basically for the NHM. And who has filed the affidavit? Respondent number
6.
6. Okay.
In paragraph 7 of my affidavit, my lord, is 3. The deponent begs to state that as petitioner was working in the capacity of block account manager at Sriram block, after signing the TOR agreement, it is the responsibility of the block account manager to make payment of ASA incentive as per guideline after checking and keeping the relevant records. That it may further be stated that as per clause number 6 of the TOR stating the job responsibilities of the block account manager, it is the job responsibility of the BAM to assist the medical officer of BPHE in ensuring proper flow of fund and all financial matters and control of expenditure. Therefore, the petitioner cannot deny his responsibility towards excess payment of incentives to ASAs and unable to control the excess expenditure. It was negligence on the part of the petitioner being block account manager. That is in Annexure A of my affidavit, my lord, page number 9. Responsibilities of the block account manager. 2, my lord. Maintenance of record of JSY fund, payment of ASA and payment to the JSY beneficiary. And that is my in 6, my lord, assist medical officer of BPHE in ensuring proper flow of fund and all financial matters and control of expenditure. And 9, my lord, assist block program manager in preparation of action plan, submitting the performance records, etc., and act as a team to achieve the goal of NRHM, my lord. That is the responsibility of the block account officer, my lord. In paragraph 8, my lord, the deponent begs to state that it is pertinent by the statement that the petitioner accept that due to negligence, excess payment was made to ASAs as incentives. The District Health Society Bongaigaon had to face various difficulties due to such negligence and resulting excess payment and excess expenditure. Recovery of same cannot be practically authenticated, though special audit was engaged by the District Health Society, my lord. Thereafter, my lord, regarding my lord negligence in paragraph 12, my lord, I have written that the self appraisal was not 12. page, paragraph 9, my lord. The deponent begs to state that the service of the petitioner was discontinued immediately when the authority found gross negligence in discharging his duties, and due to FIR against him, the charges of block account manager Susan Gram, BPHE, was handed over to other person, my lord. In my Annexure C, my lord, it is the FIR, my lord, against the petitioner.
13.
Annexure? C.
Annexure C.
Page 13.
Page 13, my lord. That is the FIR against the petitioner, my lord. I have the honor to inform you that Asim Parvez, block account and manager of Susan Gram, PHE, has paid excess amount of money as ASA inclusive to the various ASA of under the Susan Gram block PHE in the year 2012 to 2014, which may interfere some health program of the PHE, my lord. And Annexure E, my lord, that is the some supporting documents of the negligence made by the petitioner, my lord. Annexure E. It is page number 16, my lord. Cash book updated amount balance to amount. Vouchers are not arranged in chronological order. Supporting documents of ASA not attached with the vouchers. FMR code not mentioned in the vouchers as well as the cash book, my lord. Later documents regarding his negligence, my lord.
What is this clause number 6 of the DOR?
Yes, my lord, that is in page 9, my lord.
DOR means terms of contract.
Page number 9. Assist medical officer. Page number 9.
9 of the counter.
Yes, ma'am. This medical officer, my lord, in disbursement of fund as per the guidelines issued time to time, my lord.
We'll do one thing, we'll come back in the
Yes,
afternoon.
sir.
Please.
The main file is I'm paying for short accommodation for Tuesday or Lordship or any other day convenient.
Item 15.
I'm actually trying to trace it out from the office, Your Lordship. The affidavit, etc. are not available with me, and there's also some instruction also there in the file, Your Lordship. Not there, any date convenient.
On
Your
Tuesday, Lordship, if it is convenient for your Lordship.
Wednesday.
2018 matter, my Lord. Removal from
Wednesday.
service.
Any day, Your Lordship, no. I have.
As paid for by Mr. C.S. Azarika, learned counsel, appearing for the
For the state, Your Lordship.
state. List again. How about Wednesday?
Wednesday motion day actually more for hearing. actually.
Otherwise,
Or
I have-
Thursday, Lordship.
No, Thursday, not Thursday.
Yes, Your
Either
Lordship.
Wednesday. We'll have it on Wednesday. Please give the date, huh? 13 November.
Lordship, I beg indulgence, your lordship. So, but item 14 is gone. I was late, my lord. By this time, I am lordship called this item, my lord. Lordship, and only my presence may be recorded, my lord. Only the thing is, I was in lag, my lord. So, you know,
Oh, just take a note, huh? BJ Ghosh. You just put his name.
Lordship. Oh, my lord, whether it will convene to fix the date is 2017 matters appear. If your lordship, I'll convey the others. I'll inform the others.
We'll see what can be done, okay? Let me see the order first.
Lordship, I am deeply.
My lord. I'll definitely read the FIR first, my lord. Prior to that, my lord, on 4 counts, we are seeking bail, my lord. With all respect, my lord.
Before that, you just tell me what has happened to that bail filed in ISO.
To our knowledge, my lord, we applied for certified copy.
Ah.
My lord, with all respect, my lord, we didn't get anything, my lord.
Till now, no order.
No, to our knowledge, my lord, because we applied for certified copy, but we never got it.
It was last listed on 6/8.
It was last listed on 6/8, my lord.
6/8.
6/8 of August, 6th of August.
6th of August.
That amendment we have made, my lord, in my lord, page 25, para 5, page 5.
Was it heard otherwise?
My lord.
Was it heard?
Twice, my lord. Once case diary was sought for, my lord, on 1/8, my lord. Thereafter, matter again came on 6/8, my lord. Thereafter, my lord, it has never been listed, my lord. Lower court bail application, my lord.
Hearing was done on 6/8.
My lord.
Hearing was done on 6/8.
Exactly.
That's a long time, isn't it? 8, 9,
My
10. Now we're in November.
My lord.
Okay.
And meanwhile, charge sheet has been submitted, my lord.
When was it submitted?
Exactly, my lord, on the 60th day, my lord. The accused was arrested, my lord. With all
1610.
respect. Oh.
1610.
No, my lord, on 60th day, my lord.
60th day.
60th day, my lord. And charge sheet was submitted, my lord, with all respect, my lord, on 23/9/24. And date of arrest is, my lord, 26/7/24. Upon receipt of 41 capital A at that point of time notice, my lord, we appeared 2 persons, my lord. One was, my lord, that is stated in the charge sheet, my lord. He was not arrested. I was arrested, and since thereafter I am in custody, my lord.
You were arrested on 26/7.
26/7, my lord.
And charge sheet filed on 23/9.
23/9, my lord. My lord, date, my lord, pertains to police, my lord. But, my lord, the law is, lordship knows, my lord, more than me, my lord. Here it has been accepted by, my lord, as regards CRPC 167, now 187, my lord. The 60-day, 90-day period, my lord, that could begin only from the day when a learned magistrate, my lord, as per the manual, my lord, there are authorities also, my lord, is signed by the learned magistrate, my lord. That she has received, she or he has received the charge sheet, my lord. Otherwise, we get the benefit of default because applications are pending, my lord. And another.
Allegation now is under 420, 103, and 138.
60-day period offenses, my lord. 60-day period, all offenses during investigation, my lord. 60-day period offenses, my lord. 420, 403, and that too, my lord, negotiable instruments acts have been attributed. That's a non-cog offense, my lord. And bare reading of the FIR, it would be apparent, my lord, that definitely, my lord, money was paid, money is due, and hence the case. Even in the charge sheet, it is apparent, my lord, for recovery of money, the man has been arrested, my lord. Possibly that is not the Indian criminal justice delivery system, my lord. Should I read the FIR, my lord?
Yes, let us see the FIR.
Yeah, yes, my lord. That occurs at page 23, my lord.
Yes.
I'm taking a minute, my lord. Sorry. 23, my lord. May I just read it, my lord?
It's translated.
It in the, my lord, local language, my lord. It has been translated to English, my lord, page 23, my lord.
Okay.
May I just read it?
Yes.
I humbly request your immediate attention and action on the information I am providing in this complaint. In December, so-and-so informed me about a job opportunity in Mizoram, especially for road construction under the National Highway so-and-so, my lord. He mentioned that the project was owned by the son of Central Minister Nitin Gadkari in collaboration with Rajesh Kumar, contact number so-and-so. We were informed that we could secure work under them, and to discuss this further, Mr. Rajesh Kumar even traveled with us to Delhi for a meeting. Following our discussion, we agreed to work together, and it was decided that I would invest rupees 65 lakhs to secure my place in the project. The amount included rupees 10 lakh that I borrowed from so-and-so. As instructed, I transferred the entire sum to Mr. Thomas' account. Unfortunately, the road construction project from Dulte to Samphai was later cancelled by so and so. Subsequently, Mr. Thoma and Rajesh Kumar visited Aizol, where we had another meeting at Mr. Thomas' residence in so and so, which has since been closed down. During this meeting, Mr. Rajesh Kumar proposed another opportunity, inviting me to become one live member for a job related to Delhi Police Housing project at Dhirapur, allegedly worth rupees 200 crores. He stated that to secure the contract, we need to pay rupees 6 crore for EPC with an initial payment of 1.5 crore. He assured me that I'd be able to recover rupees 3 crore from this investment. Trusting his work, I deposited rupees 1.5 crore to Mr. Rajesh Kumar's account in January 2022. I have attached 4 receipts of proof. As per our agreement, he was supposed to return my capital along with interest amounting to rupees 3 crores by March 22. However, Mr. Rajesh and Mr. Thoma failed to honor the agreement, my lord. Despite my repeated requests, they only paid rupees 33 lakhs in 3 separate installments in November 22. Since then, they have not made any further payment. Whenever I followed up, they offered excuses and further delayed the repayment. Till date, they still owe me a substantial amount of money. Moreover, in an attempt to deceive me further, they issued 2 checks, one for rupees 100 crore and another for rupees 200 crore. They subsequently bounced. It is clear that Mr. Rajesh Kumar and Mr. Thoma intended to deceive me and cheat me out of my money. I request you to take prompt necessary legal action to help me recover the remaining. My lord, the affair has been lost to recover the amount, my lord. My lord, may I read this line again, my lord, with all respect and full hands, my lord. It is clear that Mr. Rajesh Kumar and Mr. Thoma intended to deceive me and cheat me out of my money. I request you to take prompt and necessary legal action to help me recover the remaining funds and to bring the culprits to justice.
What is the date of the FIR?
My lord, the date of the FIR is, my lord,
31/01/24.
31/01/24, my lord.
Okay.
Similarly placed both.
So the main person mentioned here, Rajesh Kumar.
Yes, my lord. He
Is the petitioner.
Yes, my lord.
It's the other way around, say Kumar Rajesh.
My lord.
Same thing. Kumar Rajesh, Rajesh Kumar.
Possibly, my lord, North Indian people, same person, my lord. Definitely same person, my lord.
Okay.
My lord, can I read the charge sheet, my lord?
Yes, where's that charge sheet?
Yes, my lord.
Relevant portion, page 36.
Relevant portion, my lord. Exactly, I'm putting emphasis, my lord. Page 36. My lord, there, my lord, in 36, 2 persons are specifically named, my lord. Prime accused is Kumar Rajesh, my lord, or Rajesh Kumar, my lord.
The petitioner.
The present petitioner before your lordship. He is the prime accused, my lord. And another person was there along with him, Mr. Thoma. And Thoma co-accused, my lord. Both of them received 41 capital A notices, my lord. In the charge sheet, it is apparent, my lord, at page 36.
The charge sheet starts from page 27, is it?
Exactly, my lord. Page 36 is the relevant portion, my lord, regarding these 2 accused, my lord.
Yes.
Should I read?
Yes, where is that?
My lord.
3.10.
36, my lord. I am reading 3.9, my lord.
3.9. Yes.
3.9 is Thuma. Right?
No,
my lord,
this
he is
is
Mr. Thuma, my lord. I leave aside the first paragraph, my lord. These are names and everything. That huge paragraph, there are 4 above agreements, my lord. They had deposited huge amount of, lordship has found, my lord.
Yes. Which one do you want to read? 3.9.
3.9. I leave aside first paragraph, second paragraph, start small paragraph, my lord. 4th I begin, my lord.
Yes.
For the above agreement.
Yes.
For the above agreement, they have deposited huge amount of money to the accused person, and later on they came to know that they have been cheated by the accused party. His statement is enclosed in so and so, my lord. Thereafter, my lord, accused so and so was given Sir, notice to appear at PS. He appeared on 4/7/24. He cooperated the investigation by making disclosure statement revealing that he pleaded guilty, truly received money 25 lakhs from so-and-so, and he used around 20 lakhs for purchase of vehicle so-and-so, which is still being held by him, and he promised to hand over the said car so-and-so. The said vehicle bearing number so-and-so, engine number so-and-so, so-and-so, was produced by him and seized on 27/24. Seizure intimation given to CGM Aijol. Hence, he has not been arrested. Hence, he has not been arrested. And he cooperated the investigation. Notice under section 41A CRPC, his statement, disclosure statement are enclosed herewith. Thoma is released, my lord, with all respect, my lord, same FIR. Because money was due, my lord, money was due, and the FIR was fine. Definitely, my lord, duping is there. No two ways about it, my lord. Have I made my position clear, my lord? From bare reading of the FIR. But the case has been lost to, my lord, get the money which was paid, my quid pro quo, my lord. So this police case was raised. That cannot possibly be done. With all respect, my lord, there are authorities also. And second paragraph I am reading, my lord, I have been booked. And why I have been booked? That I could not return the money, my lord. That is not the Indian criminal justice delivery system, my lord. Because they have also done negotiable instruments act for recovery of money. They can go for money suit, my lord. But by lodging a criminal case, definitely, my lord, he will face the trial. But detaining him, my lord, so that the money is paid, that cannot be, my lord. May this paragraph, my lord.
You may be punished, but they'll not get the money back.
Money
In a criminal case.
Lordship is very correct, my lord.
You may be convicted and punished with imprisonment.
That's criminality.
But that money will not come.
Exactly. My lordship is very, very correct. I am harping on it, my lord, because they have also lost their negotiable instruments act. My lord, NI Act case, so far as the first information report is concerned, a check bounced. And that is why, my lord, 138 is attributed, my lord. That's a non-cog offense, my lord. And they can go for money suit also, my lord. Have I made my position clear, my lord? But this paragraph I am reading, my lord, I have been booked because I could not pay back the money. 310, married, my lord.
Yes.
Accused Kumar Rajesh, is Rajesh Kumar ne Kumar Rajesh? I'm sorry, my lord. Accused Kumar Rajesh, son of so-and-so, Delhi, was issued a notice under section CRPC. He appeared, my lord. He appeared, my lord. On his appearance on 60, same date, my lord, as the earlier one, my lord. He was examined, who stated that he truly received money from the complainant. He had no any connection with the two companies he has mentioned in the agreement prepared by him and signed with complainant, my lord. This is very important, my lord. See, he could not return the money as of now. Next time reading out, my lord. It will be there. D is, my lord, he did not want to disclose information below. Any personal properties in his family, in his or in his family name, any detailed proof of transaction or business connection papers between him and Para project, which makes suspicion that he had accomplices behind the scene. He is not likely to return the money as per his statement, yet it seems that he may avoid himself or be running away from the investigation in future. Hence, as approved by the superior officer, he was arrested and forwarded to the court after police custody. His statement enclosed herewith. Second point, my lord, on so-and-so, a copy of, my lord, in the charge sheet, my lord, here, my lord, with all respect, my lord, no accomplices are there, my lord. And, my lord, FF have been submitted in absolute form, my lord. And these two accused, my lord, with all respect, I will submit, my lord. So that parity comes in, my lord. Similarly situated, my lord. Of course, possibly I am on a little bit higher degree. One was let off. I have been booked because he returned the vehicle. I could not pay the money, my lord. That can, by lodging a criminal case, my lord, for recovery of money, possibly this should not have been done, my lord.
What is the role of the other person? It was through
Same,
him.
same, my lord, in the FIR.
No,
Co-accused, my lord.
no, he's a co-accused, but through him the money had gone to you.
No, both of them took it together, my lord. I read the FIR, my lord. My lord, I'm reading the FIR, my lord. My lord, first paragraph, second paragraph, fourth paragraph, my lord. However, Mr. Rajesh Kumar and Mr. Thoma, Lordship has found, my lord.
No, before that, I
No.
deposited 1.5 crore into Mr. Rajesh Kumar's account.
Yes, my lord. Yes,
Your account.
my lord. Oh, yes, my lord.
Money has
Yes.
gone to you.
Yes. It has gone to me to him also, my lord. Can I just read it, my lord? That line total amount is 1.5 crore, my lord.
Yes.
It went into my account. May I just read it, my lord?
Yes.
He assured me that I'd be able to recover rupees 3 crore from this investment. Trusting his word, I deposited 1.5 crore into Mr. Rajesh Kumar's account in January 22, and I have attached 4 receipts of proof. As per our agreement, he was supposed to return my capital along with interest amounting to rupees 3 crore by March 22. However, Mr. Rajesh Kumar and Mr. Thoma failed to honor the agreement. Despite my repeated requests, they only repaid 33 lakhs, meaning both, in 3 separate installments in November 22. Since then, they have not made any further payment. Whenever I followed up, they offered excuses. Both were in hand in glove, my lord. Account money was paid to the present accused before your lordships to his account, my lord. But both were in the same league, my lord. Whenever I followed up, they offered my lord. To date, they still owe me a substantial amount of money. Moreover, in an attempt to deceive me further, they issued 2 checks that subsequently bounced.
Thoma was not arrested because he promised to repay the money. How can
Thoma was not arrested because he promised to repay the money, my lord. Possibly, this cannot be done, possibly, my lord. And now charge sheeted, my lord.
he arrived at a settlement after he was put behind bars? Settlement agreement with the informant and the.
My lord, in the application, we have also annexed an agreement. After arrest in the police station, in jail, my lord, they made us enter into an agreement with the informant, my lord. That also we have annexed, my lord. Page 52, my lord. Criminality is there, my lord, no two ways about it, but civil aspect is more prominent, my lord. Page 52. This is between, my lord,
Between the informant and the petitioner.
the present accused and the informant, my lord. This begins at page 52, my lord, for repayment, my lord. My lord.
By which time repayment is to be done as per this agreement?
Repayment is that I am reading and placing.
Page 56. Installment.
As my friend, page 56, my lord.
Installment.
Installment, my lord.
The first installment has been paid.
In fact, the first installment has been paid, my lord.
50 lakhs.
30 lakhs.
Oh, 30 lakhs.
30 and 33. Sorry, my lord, 30 lakhs. And thereafter, he is still inside, my lord.
Second installment by 30th November.
Yes, my lord, but he is inside, my lord.
From inside also he can pay.
My lord.
From inside also he can pay.
Possibly, I do not know, my lord, has been told to me. My lord, situation is this, to be very honest, my lord. I'm not saying that the character behind bars is a gentleman, my lord. Definitely, I'm not a man of good character, my lord. Undoubtedly, my lord. Only here, my lord, apparently till whatever position we have reached, my lord, 2 persons on the same league. I may be on a higher league, my lord. The other has not been arrested. I am inside, and I, after being inside, my lord, an agreement was signed. That is not in consonance with law, my lord. That cannot be done. And notarized, my lord. Can it happen, my lord?
27th was arrested.
27th he was arrested. It was notarized when he was inside.
No, but you have signed it,
Yes, my lord, from inside jail.
wherever it may be, but you have signed it.
No, lordship is very, I'm not this.
You could have said that, what is this? I will not sign it. Why should I sign it? You
No,
could
no,
have
my
done
lord,
that.
because that intention is good, my lord, that I took money, I have not denied, my lord. Settlement agreement because of that, my lord. But settlement agreement,
No, after signing it, now you are just questioning again.
no, I'm not questioning, my lord.
Then
We'll have to pay back, my lord, because money is due, it is admittedly true, my lord.
Cannot be used for recovery.
My lord, to that effect, there are, I'll come, my lord. Can I come to the charge sheet, my lord?
yes, please.
Now, my lord, after the agreement is there, that is during investigation, my lord. Now, charge sheet has been filed, my lord. Filing of charge sheet exactly on the 60th day. These are all 60-day period of offences, my lord. Lordship has to see one thing from the public prosecutor, my lord, whether the charge sheet was, my lord, with all respect, my lord, on which date it was signed by the learned magistrate. Can I place the authority for that, my lord? The date given by the police would not be the date as has been envisaged under section 187 BNS.
You are pressing for the default bail.
Oh, that is also a ground, my lord, because we do not know on which day it was signed, my lord. Default is also there, my lord. Primarily on merit, my lord, and thereafter default, and thereafter, my lord, that my lord, that Prabir Puruka is the case, my lord. My lord, with all respect, my lord, that is apparent on face of the record, my lord. At the time of arrest, my lord, 47 was not complied with. First of all, my lord, Article 22(1), my lord. That my friend can reply, my lord, to government side.
Yes.
That he can reply, my lord. Two things, primarily we are seeking bail on this ground. On merit, my lord, that I have already placed, my lord. Agreement and everything. My lord, that is one part, my lord, with all respect, my lord. Now it has been charge sheeted, my lord. And now, my lord, the grounds we are seeking bail, my lord, with all respect, my lord. First of all, my lord, that default, my lord. Default would be apparent, my lord, if the authority who is to receive it, my lord, my lord, with all respect, my lord, in the CGM's office, that PI's office receiving it, prosecuting inspector's office receiving it, is no receipt, my lord. With all respect, my lord. It has to be endorsed by the learned magistrate, my lord.
Yes.
That is one part, my lord. These are and the authorities regarding that are, my lord. With all respect, my lord. First, let me just place it, my lord. Our High Court authority, my lord. Samsul Nur to the sir. My lord, this authority states, my lord, when charge sheet is submitted, my lord.
What is the authority?
Samsul Nur, my lord.
It's not reported.
My lord.
It's not reported.
Not reported, my lord. Reported.
So give me the judgment date.
Application 1958.
My lord, the judgment date is, my lord, judgment date who is
7/10/22,
my lord.
In bail application.
In bail application number 1958/22, my lord.
1958 of 22.
22, my lord.
Party's name? Party's name?
Party's name, my lord.
Samsul.
Samsul Nur versus State of Assam. May I read?
Yes.
Para 23, relevant paragraph, my lord. I'm sorry, 33, my lord.
Yes.
May I read, my
Yes,
lord?
yes.
Now coming to rule 69. Here, my lord, Assam rules. We have quoted the Mizoram rules also. My lord, perimeteria, my lord, we have quoted those rules also, my lord. Now coming to rule 69, it would be seen that as soon as the final report of a case are received by the court officer, whether it is a charge sheet or a final report form, he will fill in column 10 to 14 of the register and again submit it with the final report or the charge sheet to the magistrate. The magistrate thereupon, if a charge sheet has been submitted, will either take the case to his own file or will pass orders to be entered in column number 15 as to which magistrate is to try the case. This Rule 69 also would show that it is the duty of the court officer to place it before the magistrate concerned, and upon a conjoined reading of Rule 38 and 69, it would show that, so far as Assam Police Manual, same as the Mizoram Police Manual, my lord, we have quoted it, my lord, that the Assam Police Manual categorically mandates that it is the magistrate who has to put the initial as regards the receipt of the charge sheet and in the general register, and not the ministerial staff of the office of the court magistrate. If, my lord, the signature was not put in the charge sheet on that date, my lord, on which date the charge sheet was submitted, with all respect, my lord, and the date is 23/9/24. If the receipt date is subsequent to date, or no receipt date is there, my lord, he gets the privilege of, with all respect, my lord, default bail, my lord. Rakesh, what do you mean? My lord, lordship would kindly now, my lord, paragraph 10 of our application, my lord. Page 9, para 10, my lord.
What is the paramateria provision under the?
Exactly, my lord. Page 9, para 10.
Yes.
If it is read, my lord, exactly the same, my lord. Only the numbers are different, my lord.
644,
Exactly, my lord. And we have annexed it also, my lord. Now, my lord.
Yes.
With all respect, my lord, when charge sheets have been submitted, my lord, the applications are to be pending, my lord. Our applications definitely were pending. So far as we are concerned, my lord, because we moved our applications way back on 1/8 and 6/8, my lord. 6/8, my lord. And now may I just read, my lord? Rakesh Paul, my lord. This has opened the floodgates, my lord. Should I?
What is that?
2017. 15 SCC, page 67, my lord. 2017, 15 SCC, 67, my lord. Paragraph 44, my lord. May,
yes.
May,
yes, read.
Strong words indeed. Para 44, my lord. That being so, we are of the clear opinion that adapting this principle, it would be equally be the duty and responsibility of a court on coming to know that the accused person before it is entitled to default bail, to at least apprise him or her of the indefeasible right. Even this was not informed to us, my lord. That on the 16th day or on the 19th day, as the case may be, my lord, the magistrate is to inform the accused, if charge sheet is submitted, that he has an indefeasible right if charge sheet is not submitted. This was never informed to me, my lord, just as a matter of reference, my lord. A contrary view would diminish the respect for personal liberty, on which so much emphasis has been laid by this court and is evidenced by the decisions mentioned above, and also averted in Nirla Yadav, my lord. Thereafter, my lord, I am reading para 45, my lord. On 11/1/2017, when the High Court dismissed the application for bail filed by the petitioner, he had an indefeasible right to grant of default bail, since the statutory period of 60 days of filing charge sheet had expired. No charge sheet or challan had been filed against him, and the petitioner had only applied for default bail. Had orally applied, even oral application would do, my lord. When the charge sheet is submitted, accused is brought before the court, he is asked that whether you would be intend to go out on bail or not, my lord. If no written application is there, even in that event, oral application would suffice, my lord. It goes on and on, my lord. So this is the situation. Thereafter, this is the situation, my lord. With all respect, my lord. Our applications were pending, my lord.
60 days starts counting from.
60 days would end exactly on that day, my
Would
lord.
start from date of.
The date of arrest, my lord.
Date of arrest.
Date of arrest. The date of arrest is, my lord. Date of arrest, I have page 7, my lord. Page 7 of the application, my lord. Page 7 of the application, para 6, my lord. It has been computed, my lord. Lordship has found, my lord. Page 7.
26/7/2024.
Exactly, my lord. 60 days would be 23/9, allegedly on which date the police may have submitted the charge sheet, which is with us, my lord. But that submission of charge sheet, my lord, would not, my lord, with all respect, my lord, diminish the default bail clause, because the reason that mere placing it before the court undo, it has to be signed by the learned magistrate in the manner as has been prescribed in the authority concerned, they read out before your lordship's prior hand, my lord. Have I made my position clear?
What is this breakup given in this page 7?
Breakup is, my lord, July, he was arrested on 26/7. So 6 days in the month of July, my lord, to count the days, my lord.
Okay, to count the days.
Exactly, my lord. And 31 days in August, my lord.
July, August.
July, August.
Then-
And 23 days in September, my lord.
Okay, like that.
So it is absolutely, my lord, on the 60th day, it was submitted. But, my lord, that submission undo, it has to be received by the magistrate with his initials, along with the procedural, those, my lord, formalities, those books and everything, signature and everything. My lord. Otherwise, it would be subsequent to 60 day, my lord, meaning thereby subsequent to the date of filing of charge sheet, my lord, which is 23/9/24, my lord. And that by in that manner, default bail will accrue, my lord. Default bail will accrue, my lord. And thereafter, my lord, I have placed this one, my lord, so far as default bail, and my lord, that Rakesh Kumar Paul, my lord. Rakesh Kumar Paul and our Guwahati High Court Authority, my lord. And my lord, now in the charge sheet that I read out, my lord,
Yes.
2 persons named in the affair, although lordship was very correct, my lord, money came to my account, a huge part of it, my lord. Both were together in committing the alleged offense of 420 and 403, my lord. And the Negotiable Instruments Act also, my lord, because they repaid the 30 lakhs together, my lord. Have I made my position clear, my lord?
How?
No, it is there in the their language, my lord.
They paid together.
Yeah. Yeah. May I just read it again, my lord? I'm emphasizing it, my lord. If I can read it,
They only repaid 33 lakhs.
Exactly, my lord. That's the language, their language, my lord.
Where's the vernacular? It's not
My lord?
legible.
Vernacular is, my lord. Vernacular to put so.
Page 20.
Page 20, my lord. It is English kone kori.
Yes.
My lord, this is so far as my lord, with all respect, my lord, it parity goes. Total payment, my lord, already 63 lakhs have been paid back, my lord. From jail 30 lakhs, my lord. As per FIR 33 lakhs, my lord.
Plus the car has also been seized.
And from my co-accused, my lord, who is not before your lordships, who was let off, my lord, the vehicle also was taken back, my lord. Now, my lord.
Regarding repayment from jail.
Jail, my lord.
You're referring that from the agreement?
Yes, yes.
Any statement you have made anyway?
I mean, positioning statement.
That was paid.
That will come, my lord. We have annexed the agreement, my lord. I may have given, let me check, my lord. But this is genuine, my lord. Whatever is there, we have placed it, my lord.
No, since you said that you've repaid 30 lakhs from jail.
In the agreement, it is there. From there, I have
Agreement, it is there, no doubt, but
Direction.
payment is something else.
Yes, yes, sir.
Sure.
Yes, it is there. My lord, one receipt paper is there. That would be placing, my lord.
Just give us a moment.
Didier. Right?
40,000 debt to so I can't keep it.
Because, no? Didier.
Agreement also. Instrumental.
I'm taking a minute, my lord. The receipt is which has, my lord, will be placing.
Installment.
My lord, this is the receipt, my lord. Same number, my lord.
Dated?
Dated, my lord, 1/8/24 after his arrest, my lord. Tally
From the agreement, it can be tallied, my lord.
the account number. Oh. 29 lakhs 40,000.
My lord, 30 lakhs was not paid, my lord. 29 lakhs 40,000. 60 episode dibo pare.
But you did not mention this in the bail application.
No, you have not mentioned that.
The agreement was signed, this much has been given.
Yes, yes, my lord, but this is possibly, my lord, the earlier parts were not honest, my lord. After drafting, possibly.
Okay.
This is one part, my lord. Now, my lord, the parity, of course, my lord, occurs when one order is there from a court of law. The second order need be like that, my lord. Here, my lord, of course, we are citing one parity authority, my lord, that was rejected by this Honorable High Court. Then, my lord, apex court said no, parity has to remain, my lord. But here, parity is, my lord, two persons named in the FIR, 41A invitation, my lord. They appeared, my lord. One was put behind bars, my lord, because non-payment of dues. He refused at that point of time, my lord. And but one was let off, my lord, because he deposited his vehicle and everything, my lord. Have I made my position clear, my lord? And regarding parity, my lord, one authority of our High Court, my lord, with all respect, bail application number 2022/23. Date of judgment 19/7/23, my lord. There, Anjan Nath versus State of Assam. There, NDPS commercial quantity, my lord. One co-equal was granted the privilege of bail, but the Honorable Court was of the opinion, my lord, para 21, last parting lines, my lord. Para 21, my lord. This court also finds force in the submission of the learned additional PP. There is no concept of parity in considering the prayer for bail. It was held like this by a coordinate bench of this Honorable Court, my lord. Then the matter went to apex court, my lord, and the apex court said, my lord. Apex court is, my lord, SLP criminal 9860/23, my lord, dated 17/10/23.
Same party name.
Same party name, my lord. Para 3, my lord. May I read?
Yes.
Taking into consideration the fact that the similarly circumstanced accused has already been released on bail by this court, we are inclined to grant bail to the petitioner. So apex court, my lord, nullified it, my lord. Now, my lord, with all respect, my lord, হেৰি to দিবা নেকি ৰামধৰণে কি আছিল এইটো নহয় এইটো নহয় নহয় ৰামধৰণে কি এইটো হেৰি কম নাছিল ডিফল্ট বেলৰ ওপৰত ৰবীন্দ্ৰ নালাগে my lord, Ravindran is also there another authority, but it would be, my lord, with all respect, multiplying the same authority again and again, my lord, not possibly necessary, my lord. Now parity also goes, my lord. First, the default we have placed, my lord. On the point of parity, we have placed, my lord. Now, my lord, with all respect, my lord, let me come to Article 22(1), my lord. Because no arrest memo was provided to us, my lord. Earlier, it was Section 50, my lord, Code of Criminal Procedure. Now, my lord, Section 47, my lord. 47 of the BNSS, my lord. BNSS. And it, my lord, that statutory right, with all respect and folded hands, my lord, it emanates from Article 22(1), my lord. Article 22(1), my lord. May I just read it, my lord? Yes, sir. Article 2.
No one said we deprive of liberty except as per.
My lord, now in 24.
That is the one.
24, it has been reiterated, my lord. 24, it has been reiterated, my lord.
24 of?
This year, my lord, by an authority of the apex court, my lord.
I see.
That it is a must in all cases, my lord. That also I'll read if your lordship permits, my lord. Can I come to the article, my lord?
Yes, 22(1).
With all respect and followed hands, my lord, 22(1), my lord. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest. I stop there, my lord.
Constitution, not this. Yes, please carry on.
My lord, yeah, that is it, my lord. The constitutional mandate, my lord. He cannot be detained immediately or as soon as those terms, my lord, that it be given to the accused on which grounds he has been arrested. Otherwise, my lord, if police custody is sought,
yes.
Yeah. (22)(1), my lord. Lordship has found, my lord. With all respect, my lord, no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for which such arrest, and shall not be denied the right to consult and to be defended by a legal practitioner. This is not material, my lord. Prior party is material, my lord.
So, why are you reading this section? You were not informed about the reason for your arrest?
Yes, my lord. That and on that ground itself, my lord, in even UAP cases, my lord, unlawful activities prevention,
But how do you say that? On what basis?
Because 47 was, it has to be in writing, my lord. It is to be given to me, I have to receive it, my lord. 47 of the BNSS, my lord. It flows from, no, this is a constitutional mandate, my lord. Thereafter, it has been incorporated in the statute, my lord.
47.
BNSS, right?
That show from the record.
That from the record, it would be apparent, my lord. It was never served on us, my lord. My lord, this constitutional mandate, my lord, thereafter it has been entered in the statute, my lord. And now, earlier it was 50 CRPC, now it is 47 BNSS, my lord. Can I just read it, my lord?
Yes.
Section 40 BNSS, 47, my lord. Person arrested to be informed of grounds of arrest and of right to bail. Subsection 1. Every police officer or other person arresting any person without warrant, here without warrant, my lord, shall forthwith communicate to him full particulars of the offense for which he is arrested or other grounds for such arrest. My lord, the constitutional mandate has been incorporated in the statute form, my lord, and now it exists in section 47 of the BNSS, my lord. Now, my lord, violation of this, my lord, with all respect, my lord, so far as we are concerned, our instruction is, my lord, it was never served on us because the accused is to receive it, my lord, by way of putting his signature, my lord, in the 47 that format, my lord, which is there in the, my lord, BNSS, my lord. Now, my lord, that authority, my lord, 2024, 8 SCC, page 254, Probir Purukayastha versus State of Delhi. May I?
Yes, what is the paragraph?
Paragraph 19, 21, and 48.
48.
48. This is exactly tailor-made like our case, my lord, because here, after so many days in detention, my lord, 106 days, my lord, the case has been charge-sheeted. And in this case also, my lord, it was charge-sheeted. Even thereafter, my lord, the accused was allowed to be on bail, my lord, with all respect, my lord. I'm reading para 19, my lord.
Yes, read.
With all respect, my lord. Para 19. Resultantly, there is no doubt in the mind of the court that any person arrested for allegation of commission of offences under the provisions of UAAP, the heinous offence, my lord, or for that matter, any other offences, has a fundamental and statutory right to be informed about the grounds of arrest in writing, and a copy of such written ground of arrest have to be furnished to the accused person as a matter of course and without exception at the earliest. The purpose of informing to the arrested person the grounds of arrest is salutary and sacrosanct, inasmuch as the information would be the only effective means for the arrested person to consult his advocate, oppose the police custody. He was taken to police custody for 5 days or 6 days, 5 days, no grounds of arrest, custody remand, and to seek bail. Even at this stage, I am handicapped, my lord. Any other interpretation would tantamount to diluting the sanctity of the fundamental rights guaranteed under Article 22(1), which we have read out earlier, my lord, of the Constitution of India. Thereafter, 21, my lord. The right to be informed about the grounds of arrest flows from Article 22(1) of the Constitution of India, and any infringement on this fundamental right would vitiate the process of arrest and remand. May a fact that a charge sheet has been filed like this, my lord, in the matter would not validate the illegality and unconstitutionality committed at the time of arresting the accused and grant of initial police custody remand to the accused. I was even granted the privilege of police custody, privilege to the police, my lord. And thereafter 48, my lord. I am also reading 47, my lord, as a matter of abundant caution, my lord, with all respect, my lord. We have carefully perused the arrest memo. Here, my lord, we have not been provided with an arrest memo as envisaged in 47, my lord, and find the same nowhere conveys the ground on which the accused was being arrested. Even if arrest memo is given, provided the grounds are not specifically specified, the arrest is illegal, my lord. The arrest memo is simply a pro forma indicating. It is in a pro forma form, my lord, in the BNSS, indicating the formal reasons for which the accused was being arrested. Now 48, my lord. It may be reiterated at the cost of repetition that there is a significant difference in the phrase reason of arrest and grounds of arrest. The reason of, even in the 47 form, my lord, reasons given are not the grounds of arrest, my lord. Grounds of arrest, the reason of arrest as indicated in the arrest memo. Arrest memo is different. Section 47 document is different. Are purely formal parameters to prevent the accused person from from committing any further offense. For proper investigation of the offense to prevent the accused person from causing the evidence of the offense to disappear or tampering with such evidence in any manner, to prevent the arrested person from making inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the investigating officer. These reasons should commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest should be required to contain all such details in hand of the investigating officer which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informed in writing, my lord, must convey to the accused all basic facts on which he was being arrested so as to provide him an opportunity of defending himself against the custodial remand. I was taken to police custody, my lord, and to seek bail. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated with the reasons of arrest, which are generally in nature, my lord. That is given in the memo of arrest, my lord. Etu kun section? Huh? My lord, even if it is given in the arrest memo, which is now 36B of the BNSS, my lord, that won't suffice, my lord. Have I made my position clear, my lord? Arrest memo is different and 47 document is different, my lord. That is the tenor, possibly, my lord, as a student of law, my lord. So it has to be specific, my lord. Police custody is sought for. How I can oppose it, my lord, if I don't know? I seek bail without being equipped. Why I was arrested, one was let off. All these things have to be incorporated in that 47 paper, my lord. Not paper, my lord. That's statutory document, my lord.
Yes.
And here, my lord, what has happened, my lord? He was allowed to go on bail. My lord, that paragraph also I'm reading out, my lord. As a matter of reference, my lord. 52. Para 52, my lord. 52, my lord. Though we would not have been persuaded to direct the release of the appellant without requiring him to furnish bonds, because without bonds he would have been released. But as because it was charge sheeted or security, but since the charge sheet has been filed, we feel it appropriate to direct that the appellant shall be released from custody on furnishing bail and bond to the satisfaction of the trial court, my lord. This condition was put, my lord. That's a key. No, প্রবীণ পুরুষ এটু পড়িল নেই এটু কোনটো প্রবল প্রয়োগ কমলা টেটি পারে নেই এটু কি না লাগে বিমলা টিওটি দে কোনটো my this case relates to, my lord, that, my lord, money part of it, my lord. Money part of it, my lord, that by lodging a criminal case, there is a negotiable instruments act case, there could have been a, my lord, money suit, but, my lord, despite having those avenues open, my lord, if a criminal case is lodged, primarily, my lord, I have read the FIR, my lord.
Yes.
There it is apparent, my lord. Yes, criminality is there. I do not say that criminality is not there. But despite there being criminality money, my lord, FIR was primarily lost as because the money due was not paid back. To extract the money, my lord, lodging of a criminal case is deprecated in the Indian criminal justice delivery system. And this is, my lord, with all respect and folded hands, my lord, 2023, 11 SCC 607, my lord.
Para?
Bimla Tiwari, my lord.
Paragraph?
Paragraph, my lord. 9, 10, 11, my lord. And 18, my lord.
Here the petitioner went for cancellation of bail.
Here, my lord, petitioner went to the apex court as regards cancellation of a bail order, my lord. Now, my lord, this authority in para 10, I'm reading, my lord. Para 9, my lord. We have indicated on more than one occasion that a process of criminal law, particularly in matters of grant of bail, is not akin to money recovery proceeding, but what has been noticed in the present case carries the peculiarities of its own, like our case, my lord. We would reiterate para 10, my lord, that a process of criminal law cannot be utilized for arm twisting and money recovery, particularly while opposing the prayer for bail. The question as to whether pre-arrest bail or, for that matter, regular bail in a given case is to be granted or not is required to be examined, and the discretion is required to be exercised by the court with reference to the material on record and the parameters governing bail considerations. Thereafter, my lord, leaving aside, my lord, I'm reading the whole, my lord, putting it in other words, in a given case, the concession of pre-arrest bail or regular bail could be declined even if the accused has made payment of money involved or offers to make any payment. Even in that event, it can be utilized. And in the same manner, the reverse would take place, my lord, that money has not been paid back, would not be a consideration, possibly, my lord, not to grant bail, my lord, or to refuse bail, my lord. In a given case, the concession of pre-arrest bail or regular bail could be granted. Para 11, my lord. We further emphasize that ordinarily there is no justification in adopting such a course that for the purpose of being given the concession of pre-arrest bail, my lord, bail word is not here, my lord, all the same genus. The person apprehending arrest ought to make payment. Recovery of money is essentially within the realm of the civil proceeding. And my lord, in the instant case, with all respect, my lord, in a criminal case, my lord, where, because criminal case normally, my lord, non-cog offenses cannot be attributed. Non-cogs are primarily bailable, my lord. There has to be a warrant from a court of law. In this case, my lord, two non-bailable sections are attributed. Only one, my lord. Only 420, my lord. 403 is bailable, my lord. For 420, my lord. Quantum of, my lord, during investigation, detention is during investigation 60 days, my lord. And there also, my lord, a non-cog section has been attributed, section 138 of the Negotiable Instruments Act, meaning thereby recovery proceedings are on or off. So these are our prayers, my lord. So many times, definitely, my lord, I do not say, my lord, reading it threadbare and, my lord, prima facie or ex facie, my lord, criminality is there, my lord. I never say that it is not there, but it cannot be in this manner, my lord, possibly, my lord. And my lord, 106 days behind bars as on today, my lord.
Okay. Yes, PP.
Yes, my lord, before I start my argument, if my learned friend, the respected senior counsel, my lord, would agree to honor the settlement agreement that is made between the complainant and the present applicant on first day of August 2024. And in default of that, if he can be rearrested, then I will make the argument short, my lord.
Just a minute. Can we increase the volume a bit? I think the sound is a bit low. Yes, you were saying, actually the sound is a bit low. That's why I could not make out what you were saying.
Yes, I will try to talk slowly, my lord. If my learned friend, the learned counsel for the petitioner, would agree that to honor the settlement that is made on first day of August 2024.
Yes.
They are willing to honor that.
Hmm.
And if default would be held liable, then I will make I will not make my argument. If they are willing to that.
No, if they agree to honor the agreement signed on 1st of August 2024, you will not make submission. Hmm?
Yes, my lord.
No.
Because they have
What
made
kind
an
of proposition is
agreement.
that, PP? You want to make your
In
argument
order
on
of
merits.
that, my lord, they have already deposited.
They may have deposited. If you have
Yes,
heard the
my lord,
arguments
because they
that have
have
been
already.
made, that's beside the thing, no? Whether they deposit or
Yes.
not, the question of the petitioner being behind bars has to be considered. He may
Yes,
or he
my
may not pay.
Yes. First, let me start with the default bail application, my lord.
Yes.
Now they have I have received this copy on 28th October 2024, the present application. Now it is the case of the petitioner that they have a pending application before the learned trial court,
Yes.
but they do not produce any material to show that they made an application for default bail before the learned trial court. Now they might have an application that is pending for bail application, but is that default bail application?
Yes.
They do not show that. And so the question of default bail in this case would not arise, my lord. Because in my limited knowledge, my lord, if default bail is to be sought for, it has to be made on the expiry of the default at the time period that is specified by the statute. On that day, supposing if it ends in the instant case, the 60th day is 23/9/2024. Supposing if they made an application on 23rd or 24th of September, then application would suffice. But then it is their case, admittedly, that they have a pending bail application before the learned trial court, but that is a regular bail application, not a default bail application, my lord. Now, even though in the grounds of bail here in the instant bail application, they have mentioned the default bail, but then, my lord, at the time when this instant bail application was filed, that is sometime in the month of October, charge sheet was admittedly already submitted before the learned trial court, my lord.
No, that is why. What is the instruction on that? Didn't you seek any instruction on that? Whether any such kind of bail application is pending before the trial court?
My lord, problem was that the CJM was on leave, and she will be court will resume only next week, my lord.
No, in the absence of CJM, somebody else will be there in charge.
My lord, today their matter was fixed, and I believe that it is adjourned as of now.
No. CJM was leave on since when?
My lord, I was informed that she will be back from the UK only next week.
No, she's on leave since when? The
My lord,
first order was passed by this court on 30th of October. Since then, she's on leave.
My lord, the only information that I have is that she will be back on next week.
Yes, then.
But anyway, my lord, if they are going to make that the grounds of bail, then they have to show it before the court that they have made a default bail application and is pending. But then, as per their submission, it is only the regular bail that they have made before the learned trial court that they have mentioned.
Okay.
And second is that, my lord, they say that it is the case of the petitioner that there is parity between the co-accused. But my lord, I say that there is no parity between the co-accused in as much as the co-accused cooperated with the investigation while the present petitioner did not. And my lord, it is not the case that the bail application was before the learned trial court and then he was released, but then
the speaker is up there.
His co-accused was let off by the investigating agency, not the court. And the citation which my learned friend have relied upon is not applicable in the instant case. And my lord, I believe that I have sent the anticipatory bail application, which was disposed by your lordship, White order dated 24/10/2024. I have sent a copy of the order, my lord.
Yes.
Yes, my lord, if I may take your lordship kind attention to that. This is the anticipatory bail application 12 of 2024.
Yes, what about this?
Submitted by the co-accused.
Hmm.
So he was protected by anticipatory bail. But in this also, what I would like to mention is that it does not concern the instant case, but then your lordship was, maybe it's a bona fide mistake, but then the honorable court was misguided into thinking that the case was before the NIA, National Investigating Agency. If I may read, my lord, in paragraph number 2, page number 3, paragraph number 2, page number 2, sorry, last line, my lord. In view of the above, issue notice to the state returnable by so and so, the applicant shall serve notice to Mr. C. Zoram Tanalanit, Special Public Prosecutor under the NIA. So,
I've got your point. I've
Yes.
got your point. You need not read everything.
Yes.
Only thing is that on that day there was nobody, and on this date of 24/10/2024, there was an additional PP standing before me.
Yes.
Nothing was pointed out.
Yes, my lord. Anyway, what I would like to point out is that there is no, it is the case that there is parity, but then what I would like to submit is that there is no parity between the co-accused,
Why do you say that?
because he was.
Please elaborate. Just saying no parity will not do. Elaborate.
Yes, my lord, because he have submitted an anticipatory bail and he is protected by the court. No, so that is why he is not arrested. So that is why.
Anticipated bail base.
So so for this ground, the ground taken by the petitioner is not applicable in this instant case. And last, yes, and last is the arrest memo. If I'm not mistaken, 3 grounds are taken by my learned friend. No arrest memo. Now I have gone through the records, my lord. Arrest memo is annexed in the final report also. That is the charge sheet.
Page.
Page 39. Enclosure number 3, Annexure 3, arrest memo in respect of accused Kumar Rajesh.
Yes, arrest memo. So?
Yes. So, my lord, arrest memo is there. And then they have made the arrest memo in writing.
Yes.
Yes. So there is no violation of law, my lord, in this aspect. And considering the form and style, the modus operandi that is adopted by the petitioner, and the non-cooperation attitude of the petitioner, my lord, and the amount that is involved, it is my humble prayer that, my lord, that the petitioner may not be released as of now. And my lord, in this regard, I would like to place my reliance on the authority. It's 2024 SCC online SC 2271. 2024 SCC online SC 2271.
Paragraph?
paragraph, starting from paragraph number 18, my lord.
Yes.
May
This
I
is
read,
re-
my lord?
This is regarding,
This is regarding this is regarding the interest of depositors, protection of interest of depositors. It's a corporate, it's a society based, and then there was a fraudulent misappropriation of money, my lord, wherein bail was already granted and it was cancelled by the apex court, my lord. So may I read, my lord, para 18?
yes,
Okay.
read.
Yes. Sorry, my lord, I am a little bit lost. Having given our anxious thought to the controversy, we find that the exercise of discretion by the learned single judge in impugned order under section 3439 subclause 1 of the CRPC granting bail to the respondent number 1 cannot be sustained. Court, while granting bail, are required to consider relevant factors such as nature of acquisition, role ascribed to the accused concerned, possibilities, chances of tampering with the evidence and witness, flight risk. And my lord, I'll just come to the next para. While considering whether bail ought to be granted in a matter involving serious criminal offense, the court must consider relevant factors like nature of acquisition made against the accused, the manner in which the crime is alleged to have been committed, the gravity of offense, the role attributed to the accused, the criminal antecedents of the accused, the probability of tampering with the witness, and repeating the offense. If the accused are released on bail, the likelihood of the accused being unavailable in the event bail is granted, the possibility of obstructing the proceedings and evading the court of justice, and the overall desirability of releasing the accused on bail. My lord, in this respect, what we can see from page number 37 of the bail application, that from the bail application, page number 37, the non-cooperation attitude of the petitioner, that he do not want to disclose any personal properties or his family's names, etc., and detailed transaction of business and connected papers, etc. And he is not likely to return the money as per his statement. And he may be avoid or be running away from the investigation in the future. My lord, now the present petitioner is a resident of New Delhi, and unless there is something to show that to trace him, then he is at flight risk, my lord. And there is every chance of tampering the evidence and witnesses, my lord, and influence and witness, because a large amount of money involved and is credited to his account, and a person with this much of money would have some influence on the witness, my lord. There is a possibility of that. So, my lord, in that respect, it is my humble prayer that the present application be rejected at this stage, my lord.
Okay, that's all.
Yes, my lord.
Anything?
May I just, my lord,
Yes.
whatever I feel like, my lord.
Yes.
She has, whatever she has raised, my lord. First of all, my lord, Parity, my lord, he was let up by police. Well, lesser degree co-accused, my lord, Thoma, my lord. He got pre-arrest bail as per her, my lord. We never had knowledge, my lord. So Parity would furthermore be applicable. Two persons named in the affair, I may be on a higher pedestal, my lord. He was let off by police. Even thereafter, my lord, he got the privilege of pre-arrest bail. That will be Parity, my lord. I am behind bars for 106 days, my lord. That is my understanding as a student of law, my lord. Number one. Am I wrong, my lord? Possibly not, my lord. Because bail has been granted to a co-accused, standing either on the same footing or similar footing, my lord. And that too, the privilege of pre-arrest bail. And I am in jail, and that too, my lord, 439 application, my lord. That is one part, my lord. So parity prevails, my lord. Secondly, my lord, with all respect, my lord, another point she has raised, my lord, act minute. My lord, regarding grounds of arrest. This is redundant, my lord. On this technical ground itself, my lord, it's a certain death case, my lord. Kindly see, my lord. There it is stated, my lord, enclosed arrest memo in respect of Kumar Rajesh, page 39.
Yes.
Does it plain arrest memo undo, my lord? Have I made my position clear, my lord? Plain arrest memo, annexing it undo, my lord. It must categorically state not the reasons of arrest, but the grounds of arrest as the NB says in 47. Missing, my lord. Have I made my position clear, my lord?
But do you have this annexure with you?
No.
You don't have.
She has pointed out, my lord. My lord,
No, but this is your application.
Hello?
This is your application, including the.
From the charge sheet, she has stated, my lord. I never looked into it, my lord. I never knew that this was there. It is there. But it does not mean that the grounds of arrest have been communicated, my lord, in writing. And that too on it, there has to be a receipt of the accused, my lord.
Margin.
I'm sorry.
Miss Mary, can you hear me? You're not odd. Just you're on mute. Unmute yourself.
My lord, I unmute.
Can you hear me?
Yes, my lord.
Acha, you were supposed to produce the scanned copy of the case diary and the charge sheet.
My
Do you
lord,
have it?
I have produced the body of the charge sheet,
Huh?
and the body of the charge sheet, I have produced the scanned copy. But then the whole body cannot be produced, my lord. I have obtained this from the case IO, and I have produced the case the whatever I think is relevant in the statement of the accused and the complainant, etc. But then it's a huge volume. It spans about 2000 pages, my lord.
What you are giving is already there in the bail
Yes.
application.
Yes, my
It's
lord.
already annexed.
Yes. Problem was that I could not obtain it from the CJM, and I have contacted the case IO, and this was what the case IO have still in his file.
Without perusing the annexure itself, we cannot decide, isn't it? That what it is, whether it's only
This
basically whether grounds are there or not, all that.
Grounds of arrest, my lord, in Assam also it is never given, my lord. That is why we are getting bail from CGM's court, my lord. On this Pravir Kurukast only, my lord. One man was brought from Punjab, my lord. He was defalcation of money. He was only granted bail because the IO, that policeman from Punjab was some DSP level officer. He said, why should I show him the grounds of arrest? Then he will know everything. He will not answer my question. The other day, he was granted the privilege of bail, but the Chief Judicial Magistrate, Guwahati, my lord. Because this is a new concept, my lord. Although it was there in the Constitution, it was there in the, my lord, the rule book, my lord, statute, but it was never followed because the revision, my lord, it was never reiterated. Now, after reiteration, we have also come to know about it, my lord.
Okay.
That is one part, my lord. Firstly, my lord, parity remains. This is our case, my lord. Second, third is, my lord, thirdly, my lord, with all respect, my lord, she has said initially in her argument, my lord, that money part, my lord, whether I am to pay the other part or not, my lord. If she, as she argued, my lord, that my lord, Bimla authority I have placed before your lordships, my lord. That Supreme Court authority I placed, my lord, extracting money That from the state side, my lord, I possibly not in, I should not say, my lord, possibly not in good taste, my lord. On that ground itself, my lord, I deserve some privilege. Have I made my position clear, my lord?
Yes.
That is one part, my lord. And my lord, with all respect, my lord, that pendency of bail application, pendency of bail application is not barred. That authority I am reading out, my lord. I'm on to only to come with clean hands before your lordships, my lord. We applied for certified copy. The certified copy is annexed with our application that occurs at page, my lord, with all respect, my lord, 30. I'm taking a note. 25, my lord. This is dated 1/10/24 we applied, my lord. Page 25, my lord.
Certified copy of the?
These are, my lord. Charge sheet, all records, relevant records, my lord. Relevant records, my lord. Nothing was provided to us, my lord. And my lord, I am to only come with before your lordships with clean hands if I go to a higher authority. And my lord, that we have categorically stated in our application, and this authority supports us, my lord. With all respect, my lord. The authority law is very clear, my lord. Despite pendency, we can come. This is Usha Daruka as reported in 2024, 4 SCC, page 432. What I am to do, my lord, that I am reading out before your lordships, my lord. 22, my lord. 22.
Para 22.
2022. May I just read it out, my lord. In our opinion, to avoid any confusion in future, it would be appropriate to mandatorily mention in the applications filed for grant of bail, details and copies of orders passed in the earlier bail applications filed by the petitioner which have been already decided. This is not the case here, my lord. Details of any bail application filed by the petitioner which is pending either in any court below the court in question or a higher court. If none is pending, a clear statement to that effect has to be made. I am only to quote the applications if results are not forthcoming. Have I made my position clear, my lord? In para 21 of our application, our statements are there, my lord, threadbare.
You are stressing on paragraph 22.2.
22.2, my lord.
Details of any bail application filed which is pending either in the court below or in the higher court.
Even if I move a application before the Honorable High Court and I move CGM, there is no bar. Only I am to state, not in so many words, my lord. I am to state that an application is pending in the High Court, my lord. After Article 21, my lord. Since then, I don't know the results, my lord. Honestly, my lord.
Unlike any other provision, and unlike any other application,
my lord,
on any other subject except bail.
Except bail. Bail has to be, my lord.
In other cases, normally once you approach a forum, if you approach one forum, you cannot go and for the same relief in another forum.
Your lordship is absolutely
But
correct.
in bail, that is possible.
Bail, it is possible in such given circumstances, my lord. From, my lord, 1A, then 6A, August, my lord, till today, I do not know the outcome, my lord.
But one thing is there, the reason why this was mentioned,
my lord.
The submission of the learned additional PP was, if I'm correct,
my lord,
if I heard her correctly, is that if you go for default bail,
my lord,
that cannot be before 60 days.
I'm not saying that. My lordship is very correct.
After 60 days of expiry, you don't get the bail, charge sheet is not filed, then you apply for default bail. But what is she saying, that there is no evidence to show that your application for default bail was pending already?
No, I'm a student of law, my lord. She is partly correct, but the benefit has to accrue to me, my lord. When we file the applications, my lord, 60-day period, not even on the verge of it, attaining the maximum period, while we file the application, we are not on the verge of reaching it, my lord. Have I made my position clear, my lord? What is apex court said? Oral application would do. What is the tenor, my lord? In any bail application, what are the two prayers, my lord? That I abide by any condition if granted bail, and secondly, I provide surety. Eto amar petition lekha ase. In every petition, in our application, it is there, we want to provide surety. If the application was not disposed of, kept pending, and if that words are there, that we need to provide surety, Supreme Court is clear in Rakesh Pal. If he does, I'll read that paragraph now, my lord. Clarify it, my lord. But one thing she is correct, my lord. When default period never started, how could you file default bail application? No. I have never said we file default applications. Have I made my position clear, my lord? Our applications were pending at a time of investigation, and to our knowledge, it is still today pending, my lord. What a default bail application nomenclature may be anything, my lord. Because the Supreme Court has said, I'll read that, my lord. Orally, my lord. Here, my lord, in our application, can arrest course kindly see, my lord. Para 45 Rakesh clarified, my lord. On 11/1/2017, when the High Court dismissed the application for bail, our High Court, my lord, and luckily or unluckily, in this case, I was the public prosecutor, APSC, my lord. It was rejected here, my lord, where the default ground was taken. I opposed to 10 names. On so-and-so, when the High Court dismissed the application for bail of the petitioner, he had an indefeasible right to grant of default bail, since the statutory period of 60 days for filing a charge sheet had expired. In this case, my lord. Had expired. No charge sheet or challan had been filed against him. Parenthesis. It was filed only on 24/1/17. And the petitioner has orally applied for default bail. One can apply orally also, my lord. It was diluted to that extent. Under these circumstances, the only course open to the High Court on 11/1/17 was to incur from the petitioner whether he was prepared to furnish bail. If so, then to grant him default bail on reasonable condition. Unfortunately, this was completely overlooked by the High Court. Did the magistrate ask us? Can she put on record? First of all, my lord, the power accrues, with all respect, my lord, and the responsibility that I am to be asked. Para 45, I am reading, my lord. Kindly see. Para 44. Strong words indeed. This being so, we are of the clear opinion that adapting this principle, it would be equally be the duty and responsibility of a court, as I said, on coming to note whether the accused person before is entitled to default bail, to at least apprise him of him or her the indivisible right. First of all, the magistrate is to tell whether he can provide surety or not, my lord. Para 44. Have I made my position clear, my lord? Yes. Have I made my position clear, my lord? Article 21 has to prevail, my lord. Because the magistrate never asked me, my lord. That is apparent, my lord, on face of the record. And thereafter, my lord, bail applications are pending. And in every bail application, one line is there, my lord. I deem to give any surety that is sought for. Have I made my position clear, yes, my lord? Yes. That technicality, my lord, that a default bail application is not pending, that cannot happen in the facts and circumstances of the case, my lord. Because when we filed the application, first application on 1/8, that was reiterated on 6/8, default I could not have sought for because the period was not complete. Have I made my position clear, my lord?
Exactly. It was not complete.
How can I? Then I came before your lordships, finding no other way out. So default remains, my lord, because it is when an application can be made orally. If I am informed of the right, the accused, that default has accrued to you. Have I made my position clear, my lord? If I say I provide surety, I am to be enlarged on bail, and that surety part is here in this judgment. Surety surety dibo lagato. Surety dibo finally.
I could one was to inquire the petitioner whether the property furnished.
Malad, this line in 45 is apparent. Malad, you cannot visualize a situation and thereafter seek an authority, my lord. The authority is very clear. In 45, it is there in black and white. The only course open to the High Court on 11/1/27 was to inquire from the petitioner whether he was prepared to furnish bail. Have I made my position clear?
All right, Mr. Mahajan, I think that's about it. We'll consider and pass necessary order.
My lord. Well, can I just? The authority she quoted, my lord. She authority is quoted. I got highest respect for her, my lord. It is 2024 SC online.
Yes.
There all sections are 2271 page number, my lord.
Yes.
There is a section there.
There the sections attributed are, my lord. 409 life imprisonment. Yes. In the first paragraph of the judgment, the sections are attributed, my lord. Lordship has found, my lord.
Yes, 409, 420,
409
467, 468,
entails if
471,
punished.
120B.
My lord. 409 is life. 420 60-day period, 7 years. 467 life, my lord. Have I made my position clear, my lord? These are non-compoundable sections, my lord. Here it is 420, so compoundable, my lord. And my lord, their depositors who has cheated, society at large, that principle won't apply. It is individual cheating between two parties. Have I made my position clear? And since I'm a rank outsider, I'll run free away from justice. But my lord, how I was arrested, 2 persons were given 41A notices. I dutifully appeared, my lord. I read that paper before your lordships. Have I made my position clear, my lord? That running away part possibly cannot be made applicable, my lord.
Okay.
Lordship asked me a query, I forgot, my lord. In between, I said something, my lord.
I don't remember to.
My lord, I'm sorry.
I think it's not very important.
I'm sorry, man.
So we'll pass the necessary orders. Actually,
Anyway, man.
I was in the midst of hearing in another case, so we'll continue with that. We'll pass. We'll get the orders probably by tomorrow.
My lord, my lord. Highly obliged. Highly obliged. Oh, I don't know.
Heard Mr. BK Mahajan, learned counsel for the applicant, and Miss Mary L. Kyankte, learned additional public prosecutor. Parties have been heard. Order to be passed separately.
My lord.
Yes.
Yes, my lord, of my affidavit, my lord, paragraph 19, my lord. Reponent.
Just a minute. Just a minute. This was item
17.
17. In your affidavit, paragraph
19.
19.
To state that due to negligence of the petitioner, excess payment was made to the ASAs as incentives. The petitioner failed to control the expenditure, which was his responsibility. That the District Health Society Bongaigaon had to face various difficulties due to such negligence and resulting excess payment and excess expenditure. Recovery of the same cannot be practically authenticated, though special audit was engaged by the District Health Society. It may be further stated that The district level officials had indicated the points of rectification to the petitioner various times, though it was not given importance by the petitioner, and therefore he was sought for show cause notice by DHS Bongaigaon on dated 28/4/2016. Even after repeated instructions, the petitioner did not rectify, my lord. This is the Annexure F, my lord, page number 28, show cause notice. It has been observed by the undersigned that lots of irregularities has been occurred in Sridham BPHC related to financial purpose mentioned below, my lord. Discrepancy related to ASA's incentive payment, improper documentation of financial records, vouchers, supporting documents, etc., excess expenditure shown against allotted budget in most of the activities FMR code, delay and irregular fund disbursement to the health institutions, often incorrect financial reporting to DHS Bongaigaon, delay in financial reporting which affect mostly submission of the district level financial report in the SIS Assam. Difference between the closing balance of cash book and monthly financial report. DRS not prepared on monthly basis. Therefore, you are hereby directed to show cause why disciplinary action will not be taken against you. Your reply should reach undersigned within 7 days, my lord. In spite of repeated, my lord, instruction from the DHS, he has not rectified his point, my lord. Thereafter, the FIR was lodged against him, my lord, which is in page 13, my
No,
lord.
just now, what were you reading? From which place? Just now you were reading from?
It is 28 page number.
Para 90.
Page number 28, Annexure F.
This was a notice to him. Any reply to this?
No.
Did he file any reply to this? You are hereby directed to show cause why disciplinary action will not be taken against you.
Yes, ma'am.
Your reply should reach within 7 days. So did he reply?
No, I have no such documents, my lord. Thereafter, the FIR was lodged against him, my lord. That is Annexure C, my lord, in page number 13. This is typed copy, my lord. I have the honor to inform you that Wasim Pervez, block account and manager of Srijangram PHC, has paid excess amount of money, the ASA inclusive to the various ASAs of under Srijangram. That is FIR was lodged, my lord.
Wasim, this is the name of the petition. Wasim
Wasim
Parvos.
Yes, ma'am.
Post title says Wasim Mansoor Ali Parvez. Same person.
Same person.
No, it's actually
Block account manager of Srijangram. It has been stated in the FIR, my lord.
Where is the original copy of the FIR?
page 14.
14. Wasim Parvez.
If I may just interrupt for
Yes.
I'll just clarify, I'm sorry to interrupt. This is not an FIR. This is an intimation to the police authority. The police authority and investigation found nothing against me. Your lordship will see whether this contains receipt and registered as Abhayapuri police station, case number such and such, under section such and such.
There's a round seal in the next page, page 14. SDM and HO.
Subdivisional medical officer, my lord. Medical and health officer.
Was anything registered otherwise? If this is an FIR, was it registered?
I have no information regarding that.
Normally on the body of the FIR, they write something, isn't it?
In fact, they could have applied for the certified copy of the FIR from the PI court out there, from the CJM court, if it is actually registered. There is nothing on record to show that. An investigation was probably made through, but they found nothing.
Thereafter, my lord, the service of the petitioner was temporarily discontinued at that time as the authority found gross negligence in duty and due to FIR against him, so there was no question of his attendance and presence arises. Therefore, the petitioner was informed by the District Health Society, my lord, Bongaigaon, regarding non-payment of monthly remuneration with effect from November 2016, my lord. That is in Annexure D, my lord, page number 15.
That I have already shown your lordship in page 45 of my report.
That is regarding with salary part, my lord. And regarding the performance appraisal, it has been stated in paragraph 12 and 13, my lord.
Of
and
your counter affidavit?
Yes, my lord.
What have you stated? Let us see.
Regarding paragraph 12, my lord, page 4. The deponent begs to state that the self-appraisal was not submitted to the District Health Society, Bongaigaon, as there was an FIR against the petitioner. That it may be stated here that the performance appraisal of the petitioner for financial year 2015 and 16 was also viewed in terms of the overall gross negligence towards his duty in all aspects as in the capacity of block accounts manager. The supporting documents, my lord, indicating overall negligence has been annexed as Annexure E, my lord, page number 16, my lord. I have shown. My lord. Page 16 is some supporting documents regarding negligence, my lord. Monitoring report of Season Gum BPH, my lord.
Monitoring report of Sri
Of Season Gum BPH, block
Primary Health Center.
Primary Health Center. These are irregularities, my lord. Case book updated of balance. Households are not arranged in chronological order. Supporting documents of ASA grants not attached with the households, which are job responsibility of the block account manager, my lord. Thereafter, my lord, paragraph 13, my lord, of my affidavit. And the performance appraisal of the petitioner for financial year 2015 and 16 of the petitioner was viewed in terms of the overall gross negligence towards his duty in all aspects as in the capacity of block accounts manager. Further, the performance appraisal report was submitted to the Managing Director, National Health Mission, Assam, by the district level performance appraisal committee for perusal and approval, my lord. Accordingly, after review of the performance at the state headquarters, National Health Mission Assam, of the NHM staff, those who secured D and E grade in their performance appraisal, the District Health Society Bongaigaon received the result of the performance appraisal of the petitioner from state headquarters, my lord. And the results are in Annexure G, my lord, page number 29. In inviting reference to the subject cited above, it is inform you that review of performance appraisal of DPMU staff for the financial year 2015 and 16 has been conducted in state headquarter NHM Assam by the Performance Appraisal Committee for respective designation, and the results of the same is attached herewith, my lord. It is page number 30, my lord. His name is in serial 2, my lord. After reviewing the performance appraisal, my lord, other committee, my lord, thereafter he was, my lord, terminated from his service, my lord. The page number 31. Annexure H, my lord. You have secured E as per result of the review of the performance appraisal of DPMU staff, my lord. So and so. Therefore, as per NHM guideline, you are hereby released from the District Health Society, Bongaigaon on 28th October 2017, my lord.
How was the review done? Performance appraisal?
It is stated in my.
Did the petitioner participate? What is supposed to be done in such kind of review appraisal? What is the step?
There we have stated this self-appraisal was not submitted by the to the District Health Society, my lord. They have sent to the state headquarters, my lord. District has sent to the state headquarters, my lord, and the appraisal committee, performance appraisal committee, my lord, they reviewed the same, my lord. It has been stated in paragraph 12, my lord.
Yes.
In my paragraph 16 also, we have said about this, my lord, that the petitioner himself have accepted that there was excess payment made to the assets, my lord, and which was an important job responsibility of the BAM as per the TOR, my lord, agreement, but he failed to perform his duty, my lord. And in the contractual agreement, employee, my lord, as per contract, my lord.
How long does the appointment last? Contractual appointment at a stretch, at one time?
Earlier it was for 5 years, my lord, and now
5 years.
on the basis of their performance appraisal, my lord, performance, they
They're extended
extended. Yes, my lord.
for another 5 years.
No, not 5 years. Every year now, yes, every year, my lord, performance appraisal
Every
has been
year.
taken.
So initially 5 years.
Earlier it was 5 years for some persons, my lord. As per the terms of contract also, my lord, 0.8, my lord, notwithstanding anything contended herein above, the service of the party may be terminated at any time by the society if the party is found to be guilty of any insubordinate in the performance of the misconduct or of any breach of non-performance, my lord. That is in the terms of contract, my lord. Which is in Annexure A of my affidavit.
Yes, anything else?
No.
You're Mr. Singha, isn't it?
Yes, Your Lordship.
Anything you want to reply?
Yes, Your Lordship. I'll just counter one thing. My learned friend has been repeatedly saying that there is an FIR. And that is the root cause on the basis of which I have been temporarily discontinued from the office. Where is the FIR? There is no FIR at all. Of course, there can be a complaint against me. But whether that complaint has reached its ultimate output and it has culminated into registration of an FIR, no. Because they could not produce the copy of the FIR. That's an intimation to the police station. As per Prakash Singh Badal, when the police is supposed to, the Supreme Court has laid down the guidelines, when you register an FIR or a complaint against any individual or somebody, there has to be an investigation to that effect. And only then the FIR has to be registered. So there was no registration of the FIR against me. Meaning thereby, prima facie, there was no fault on me. There was nothing found in the investigation, perhaps, if at all, any investigation was done. So where is that FIR, which is written as registered as Abhayapuri police station case number such and such under section such and such? That is the first question. Secondly, in their paragraph 12 and 13, that is contradictory to itself, and what I have stated comes out to be correct. In the paragraph 12, they say that as regards the statements made in para 12 of the writ petition, the deponent begs to state that a self-appraisal was not submitted to the District Health Society Bongaigaon, as there was an FIR against the petitioner. That's an admitted fact on their part. They have not submitted they have not allowed me to fill up the performance appraisal form which I was required to fill it up. Your Lordship will kindly remember that is in respect of 1516. Now, then they say that it may be stated here that the performance appraisal of the petitioner with effect from 2015 and 16 was also viewed in terms of gross negligence. I'll pause there for a moment. When they say 1516, it's 1st April 2015 to 31st March 2016. Then why you allowed me to continue till November? If my performance appraisal was not up to the mark and gross negligence, why I was allowed to continue after 1st April 2016? Para 12, your Lordship will kindly mark it, of their affidavit in opposition. That's a blatant lie being exhibited before this honorable court. The Lordship will kindly read once again that as regards the statements made in paragraph 12 of the writ petition, the deponent begs to state that the self-appraisal was not submitted to the District Health Society. Has your Lordship got it?
Yes.
Bongaigaon, as there was an FIR against the petitioner. So when did you launch the FIR? 28/10/2016. That is at page 14. So you don't allow me to submit the performance appraisal form in the month of April because there was an FIR which was supposed to be lodged against me in the month of October 2016. They're trying to improve their case, your Lordship, and as per Mohinder Singh Gill, you cannot improve your case by an affidavit. Otherwise, order bad in the beginning will become a good. paisa? Huh? Now paragraph 13 they say that as regards the statements made in para 13 of the writ petition, the deponent begs to say that the performance appraisal of the FY 2015-16 of the petitioner was also viewed in terms of overall gross negligence towards his duty in respect of all the capacity of block accounts manager. Further, the performance appraisal report was submitted to the MD Assam by district level performance appraisal committee for perusal and appraisal. Accordingly, reviewed and performance of SQ Assam staff, those who secured D and E in performance appraisal, the District Health Society Bongaigaon received the result of the performance appraisal of the petitioner from SH State Headquarters NHM. So 4/1/2017, page 45 of my writ petition does not state so. You change your stance, your lordship. Where is that FIR? Where is that performance appraisal? Where you have taken the decision that I have been involved in gross negligence, anomaly of the financial irregularities, and therefore I will not be continued in my service. The actual case, your lordship, is at page, for the petition to put. If your lordship kindly turns to para 7, page 7 of my writ petition.
Yes, you have read this already.
So the persons who are responsible was the ASA persons, ASA supervisor, AVPM, ANM, and finally the secretarial in charge. And in fact, their own department, I have just page 37, your lordship will come. In fact, their department, SDM, has categorically stated to the joint director, which I've read already. I have the honor to inform you that an excess amount of payment of ASA incentive has been done in different ASA under Srijangam block PHC by all documents of ASA forwarded by block account manager of Srijangam BHPC, said oral such and such. The excess payment, particularly in spacing of birth in family planning program, is made through genuine documents duly forwarded by all secretarial officers. So am I responsible to disburse the amount which has been forwarded by my superior authority? It is your own department who is saying so. The judgment to the I'll just hand over one judgment, your lordship. When there is a collective responsibility cast on a group of people, you cannot pick up one people and say, this is relating to a case of BRPL, and this case was decided by Justice Ranjan Gogoi in the division bench, and this went up in an appeal before the Supreme Court. The Supreme Court upheld the judgment passed by this Honorable High Court. I'll just read para. Again. Para 18, your lordship. Page 213. I'll start from para 17, your lordship. Has your lordship got it?
Yes.
All the three committees, that is the tender committee technical, along with the respondent, other 4 members were there. And similarly in techno-commercial committee, along with the respondent as member, there are other 4 members. And likewise in the price negotiation committee, Sri S.C. Goswami, such and such, and chairman Sri P.K. Borua, deputy general manager, project Sri B.D. Das, deputy general manager, TV John, finance P.K. Gogoi, were members along with the respondents. All 3 committees have proposed the deal, and it was only the respondent who has been made a scapegoat. After going through the report and the finding recorded by the division bench of the High Court, We are of the opinion that in fact the division bench correctly assessed the situation that the respondent alone was made a scapegoat, whereas the decision by all the three committees were unanimous decision by all the members participating in the negotiations, and the price was finalized accordingly. It is not the respondent alone who can be held responsible. When the decision was taken by the committees, if the decision of the committee stinks, it cannot be said that the respondent alone stinks. It will be arbitrary if all the fish stinks to pick up one and say it stinks is unfair to the matter of unanimous decision of the committee. In all the three charges, the respondent has been found guilty for not assessing the reasonable price in this report submitted by him, where the price indicated by the owner of the land was rupees 30 lakhs. The appointment of Sri I. Sharma as a valuer of the land valuation was not also the decision of the respondent alone, and the exploration of the soil and rock strata given to the company Messrs. S Private Limited was also not the decision of the respondent alone. Therefore, all the three charges which has been framed against the respondent as if he alone is responsible for the deal is not the correct approach. It is not necessary that the landowner who was given the offer at one point of time at rupees 30 lakhs would stick to that. Instead, she was intimated by the appellant company by her letter quoting the price as such and such, and the subsequently negotiated and brought out by 50.01 lakhs. So what I am on is that whether you have penalized the ASHA workers, the ASHA supervisors, the ABPN, the sectorial officials who have done it. So when there was a collective decision, I am only disbursing the fund. Yes, of course, there might have been one negligence on my part, but how can I give a go by to the direction of my higher officials when they have signed the bills, they have cleared the bills? Am I authorized to put a question on that? At best, it can be a collective responsibility. Your Lordship, this case, I would like to refer, this BRPL, this case was argued by my late senior Neela Datta before this honorable court, and it went up to the Supreme Court. And there, his junior, one of my senior colleagues, Mr. Manish Goswami, argued the case. And throughout the case, the judgment was upheld by the Supreme Court also. So my humble prayer before this honorable court is that it is admitted position that on 4/1/2017, when you temporarily discharged me out of the service, was a ground which did not exist at all on that day. Secondly, you say that my service is discontinued permanently from the month of November 2016 on the ground that my performance appraisal is found to be E, wherein I have categorically stated and demonstrated before your Lordship that I was not allowed to fill up the form and I was not called in the interview. Neither they could show anything to show that yes, I have appeared, unlike the division bench of the High Court, which I have demonstrated. They could not show that I was called in the interview and I appeared in the interview before the appraisal authority. And the third and most important thing, that there was a chain of people who are involved in this incident, and to pick up me and say and make me a scapegoat, saying that I was indulged in the entire things, is wrong. It was a collective responsibility. Of course, if something has happened, it should have been collectively done. But why the axe fell on me? And their own officer says that the bill was cleared, all those datas and everything are being furnished to me by the sectorial officers. It is their own department who is saying so. Their own affidavit, para 12 and para 13 are contradictory, which says that they have not submitted my performance appraisal form. There is no FIR submitted by them or projected by them. So what remains? It happens, Your Lordship, that in a balance sheet, every debit entry is followed by a corresponding credit entry. So there has been a scam, there has been something wrong, and somebody has to be made the scapegoat. The person who is in the lowest strata of the office has been made the scapegoat. That's it. In fact, in my additional affidavit, I have shown some of the persons have got grade C, but still they are continuing in the work. Where is the affair? There is no affair at all as on date. Even as on date. And one more very interesting things, I'll put it in page 16 of their affidavit, Your Lordship. Type copy of the relevant portion, monitoring report of Srijangam BPHC. Has Your Lordship got it? This is dated 3/12/2016. Page 16 of the affidavit in opposition.
In 17, page number 17, that is 2011-15. Data different.
No, I'm coming to page 16 first. I'll point one out.
Yes, page 16, what is there?
Monitoring report of Srijangam BHPC 3/12/2016, correct? Your Lordship will see this was prepared on 3/12/2016. Date. Cash book updated up to 29/11/2016 of the balance of rupees such and bank of such. Down below, signed on 3/11/2016. They have prepared this report on 3/11/2016 and they say that the cash book was updated up to 29/11/2016. Of course, you are preparing this report on 3/12/2016. You are preparing the report on 3/12. It is above, top.
It is typing mistake, my lord. It is in page number 22. Page number 22.
Yes, 3/12/2016.
Below also it is 3/12.
No, she could not get it, what I'm trying to say. Page 16, monitoring report of Srijangapuram BHPC, right, Your Lordship? This is 3/12/2016 at the above. And they say the cash book updated 29/11/2016.
But in
What? Let me complete. What is wrong there? Vouchers are not arranged in chronological orders. Supporting document of ASA
No,
not attached.
Mr. Singh, what is wrong with this? Because the case book is updated up till November 29th.
Yes, Your Lordship. And
And
they have
report-
prepared the report on 3/12.
Report in December.
They have prepared the
My
report.
lord, it is in origin is in page number 22, my lord.
Yes, original page 3.
The date is below 3/12/16.
But দেখা বস্তুটা আপনি বুঝি পোৱা নাই ৰব। Your Lordship, the monitoring report of Srijangram BPHC, right? It was prepared on 3/12/2016.
Yes, after the cash book has been updated.
Yes.
So what is wrong with that?
They say cash book updated 29/11/2016. So they want to say the cash book was updated up to dated only till 29/11/2016.
It should have been what?
No, it was correct because they have prepared it only 3/12/2016. So
Correct.
so this cannot be a fault upon me. They are saying that I have committed a fault, that I have updated the cash book up to 29/11/2016.
Where did they say that?
No, these are the points which they brought in against me. 1 to 10.
No, I've not been able to get you. See, the monitoring report is dated 3/12/16.
Right.
The report comes after the documents are examined, isn't it?
Okay, Your Lordship.
So the up-to-date examination was done and it was found that cash book was updated up till 29/11/2016.
Yes, right, Your Lordship, rightly got it.
So,
Right, Your Lordship, nothing wrong. I thought that was an allegation against me, therefore I was trying to counter it. And Your Lordship, all the allegations that has been leveled out here, it does not bring any, it does not go to shows that I have committed any financial misappropriation.
yes, you say the money goes to their account.
Yes, the money directly goes to their account and a considerable amount has been recovered. That is their joint director, who has said it in page 37. It is their own officer who says that a considerable amount has been collected.
Okay, I think we can close the matter.
I'll just show one of the paragraph of Mohinder Singh Gill, 1978, 1 SCC 405. Paragraph 6.
Could you just repeat again,
1978, 1 SCC 405. Paragraph কি আছে রে to? Just a minute, Your Lordship. Paragraph 8, I'm sorry, Your Lordship.
Mohinder Singh Gill versus?
Your Lordship, it is Mohinder Singh Gill and another versus the Chief Election Commissioner, New Delhi and others. That's a constitution bench judgment. I'm relying on a particular point of law on this with respect to this judgment, Your Lordship. The court says the second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to the court on account of a challenge, get validated by the additional grounds later brought out. We may also draw the attention of the observation of the course in Govardhan Das Banji. Public orders publicly made in exercise of the statutory authority cannot be construed in the light of explanation subsequently given by the officer making the order of what he meant or what was in his mind or what he intended to do. Public order made by public authorities are meant to have been public effect, and they are intended to affect the actings and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. So what I am trying to harp on is, Your Lordship, on 4/1/2017, when you discharge me temporarily because there is an FIR. Thereafter, you discharge me from the service permanently at page 49, page Annexure 12, that is 4/1/2017, page 45 of my writ petition. You discharge me temporarily because there is an FIR. Page 49, you discharge me from the service, you say that performance appraisal is E. You bring on an affidavit that in 2015-16, my performance appraisal was not up to the mark. There was an anomaly. So you have been constantly changing your stand. The order based on which, the reason based on which I was discontinued from the service has been elaborated further and changed in the affidavit, which in my humble submission, as per the Honorable Constitution Bench of the Supreme Court, you cannot.
Okay.
That is not an additional.
In my humble submission.
I'm closing the matter, I think.
All-
We have heard enough.
Who received E grade, my lord? Who received E grade, my lord, at that time?
So
all
where
were
is the performance
terminated.
appraisal
All
form?
were terminated.
Okay.
So in my
I'll
humble
consider.
submission, your Lordship will
consider
kindly
this.
direct them to pay the salary from November 2016 to till January 2017 and further to reinstate in my services with that effect, Your Lordship.
Please write, heard Mr. N. R. Sinha, learned counsel for the petitioner, and Miss
A Bora,
A. Bora, learned standing counsel,
National Health Mission.
National Health Mission. Parties have made their respective submissions. Hearing concluded, judgment reserved.
I'm deeply obliged, Your Lordship.
How many matters are there? I would like to rise. Any urgent matter, quick urgent matter?
Petitioner already dated
Hmm.
in the month of year of 2008, my lord. He filed a case, my lord, regarding, my lord, he dated from the service, my lord, incorrect fixation of pay scale, my lord. There was a certain communication made during enter 36 period of his service, my lord. He Only my lord, from two times my lord, he is promoted my lord, and more than 36 years he is entitled third gradation of financial gradation. So for this purpose, my lord,
We'll do one thing, we'll give you a date, not today.
Yes, lordship, I'm. Can it be on 26th November, my lord?
As paid for by Mr. P.K. Dega, learned counsel for the petitioner, list the matter for hearing again on 26th of November 2024.
Deeply obliged, my lord.
Item 21 is there, 22 is
Any
there.
date here. Any date may be given. 21.
21 and 22. Court master, you give a date. You give a date, you give which date ever you want, he'll give you. And if there's an interim order, you must mention that also. Okay.